What's up, everybody? Working from home today. Couldn't get away when the verdict was being read live. Watched it on 2 times speed to get caught up. And boy, oh boy, did this jury send a message, which is kind of what my guess was. I'm glad I did that video earlier today explaining punitives, and a jury coming in all dressed up like that. Usually they want to send a message. They're not going to give $5 million or whatever the defense asked. They decided they believed the Kowalski family, which is a major problem because so many people throughout the process did not believe them. And they wanted to show the Kowalski family just how much they believed their version of the events. With this verdict, they said, we do not believe anything anybody took the stand and said for Johns Hopkins. We don't believe it was great. We don't believe everybody was there to help her. We don't believe Kathy Beatty was this great lady just there to help her and didn't do anything inappropriate. We don't believe any of that. You know what we believe? We believe you held Maya there against her will. You pinned her down. You took pictures for no medical reason. You fraudulently billed her dad, creating all sorts of issues. You caused her mother to commit the worst act any mother could ever commit. You created that problem. You pushed her to that point. And that caused irreparable harm to this family to the tune of over $200 million. They asked for $238 million. They didn't quite get there, I don't think. I think it was just a little less. We're going to watch it again. I'm going to speed it up a little bit. And I know not that many people are going to come over here. Lots of other streams going on, and that's awesome. And I hope you guys are enjoying watching it live and learning so much throughout this process. But I want to talk about it real quick before we got to the punitives phase to help you understand how this works, what's going to happen. I got a lot of questions about appeal. I got a lot of questions about which ones get punitive damages. I got a lot of questions about where they came up with these numbers. So we're going to hit as much of that as we can for anybody watching this later. But we are going to run through this verdict so that I can help us explain exactly what happened when this jury came back and told Maya and her family that we believe you.
In the 12th Judicial Circuit in and for Sarasota County, Florida, case number 2018 CA 005321NC. Jack Kowalski, individually Jack Kowalski as parent and next friend of MK, a minor, and Jack Kowalski as personal representative of the estate of Beata Kowalski plaintiffs versus Johns Hopkins All Children's Hospital Incorporated defendant.
Yeah, it is brutally sad to watch, but it's also like they've already been through this. This is real. It's happened to them. These tears, I think, are thank you for believing us. Thank you for listening to us. These are not tears of the damage being done to them again. They're not being re-victimized here. They're being told, we will punish them for you because of what they did to you. We're going to make sure they never do this again. And any other hospital watching is never going to do this either, or else this might happen to them.
Verdict form. We, the jury, return the following verdict. Claim 1, false imprisonment, October 7th through October 13th, 2016, Maya Kowalski. 1, did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted between October 7th and October 13th, 2016? Yes. 2,
As soon as the answer to that was yes, okay, as soon as false imprisonment, which to have a hospital falsely imprison you is just kind of weird, especially when your parents allowed you to be there and they put on testimony that we consent to her being here. We don't want to take her home necessarily right now. We don't want to move her to another facility necessarily right now. DCF said she has to stay. As soon as that answer was yes, I was like, oh boy, buckle up, Johns Hopkins, because it's going to get ugly, and ugly it got. We're going to talk about the numbers. I'll add them up estimation wise. It's not really that important. We'll talk about why later. This was significant from the jump.
what is the total amount of Maya Kowalski damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18 based on the false imprisonment occurring between October 7th and October 13th, 2016? $2,496,000.
About 2.5 million.
3, what is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the false imprisonment occurring between October 7th and October 13th, 2016. $3 million. 4, what is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on the false imprisonment occurring between October 7th and October 13th, 2016. $67,200. 5, under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring between October 7th and October 13th, 2016. Yes.
Again, we all know that's huge and clear and convincing. So in order for them to win on these civil claims, it's the greater weight of the evidence. 51%. Clear and convincing is somewhere higher than that, but less than beyond a reasonable doubt. People are asking if there's going to be jail time. No jail time. It's a civil case. But clear and convincing evidence, higher burden. Do you think this was so bad that we need to punish this hospital? Yes. And again, before I hear another number, we know it's bad. We know it's bad. M. Dean, may God bless Beata, Jack, Kyle, and Maya. May Beata rest in peace and eternal light shine upon her. This is, I never condone somebody doing what happened to Beata or being in the position that she's in or how she was treated. But this jury found that she literally had no choice and was pushed to this to save her daughter, like was mentioned in closing argument, as you push your child out of the way of a Mack truck coming towards you.
Claim 1, false imprisonment, October 18th through October 20th, 2016. Maya
The
Kowalski.
second
6,
spot
the
where
Johns
there's false
Hopkins
imprisonment.
All Children's Hospital falsely imprisoned Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted between October 18th and October 20th, 2016. Yes. 7, what was the total amount of Maya Kowalski's damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18, based on the false imprisonment occurring between October 18th and October 20th, 2016? $1,400,000. 8, what is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the false imprisonment occurring between October 18th and October 20th, 2016? $3 million. 9, what is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on the false imprisonment occurring between October 18th and October 20th, 2016? $561,298. 10, under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring between October 18th and October 20th, 2016. Yes. Claim 1, false imprisonment, January 6th, 2017, Maya Kowalski. 11, did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted on January 6th, 2017? Yes. 12, what is the total amount of Maya Kowalski's damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18, based on the false imprisonment occurring on January 6th, 2017? $188,000. 13, what is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the false imprisonment occurring on January 6, 2017? $15 million. 14, what is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on the false imprisonment occurring on January 6, 2017? $325,000. 15, Under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring on January 6, 2017. Yes. Claim 2, battery, January 6, 2017.
So before we get to the battery, here's some important factors. We have about $26 million awarded to Maya Kowalski for the false imprisonment, the 3 counts of false imprisonment. If they go under the normal Florida statute, because yes was answered to all 3 for should punitive damages be awarded by clear and convincing evidence, the answer was yes for all 3. So we've got, what did I say, $26 million. If the normal punitive damages cap is on this case, it's 3 times 26 million, which is $78 million, would be the cap in what they can give in punitives. My guess is they're thinking bigger than that just based on the numbers they're giving here. But if on that verdict form, that's why that question is so important. Did they act with intentional conduct to harm Maya Kowalski? And did they actually harm her? What do we think they're going to check on that? I'd be pretty confident if I was the plaintiff's lawyer at this point. So if they check yes, that $78 million cap goes away. And now there is no cap on the punitives they can give for those false imprisonment counts. Let's get to battery and see if there's going to be more punitives. The punitives portion is starting at $230. KDS, the jury is going to decide the punitive damages. Now, if there is a cap, the jury can award a big number and the judge can reduce it to that cap.
17, Maya Kowalski. 16, did Catherine Beatty and any bedside nurse commit a battery on Maya Kowalski on January 6, 2017? Yes. 17,
believe
what is
her.
the total amount of Maya
They believe her. That's what this says over and over again. Do you believe me? Yes, 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 down the board.
Kowalski's damages for psychological treatment incurred in the future after she reaches the age of 18 based on a battery occurring on January 6, 2017? $4 million. 18, what is the total amount of Maya Kowalski's damages for pain and suffering, disability, physical impairment, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the battery occurring on January 6, 2017? $8 million. 19, what is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18 based on the battery occurring on January 6, 2017? $559,000. 20, under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the battery occurring on January 6, 2017. Yes. Claim 2, battery, hugs, pats, kisses, and placing on lap, Maya Kowalski. 21, did Catherine Beatty commit one or more batteries on Maya Kowalski through hugging, patting, kissing, and placing Maya Kowalski on her lap? Yes. 22, what is the total amount of Maya Kowalski's damages for
Can't be doing that to 10-year-old girls when you kick their parents out. Can't be doing that. I don't care if you're trying to be nice. You can't be doing that.
psychological treatment incurred in the future after she reaches the age of 18 based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? $8 million. 23, what is the total amount of Maya Kowalski's damages for pain and suffering, disability, physical impairment, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? $11 million. 24, what is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18 based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? $1,000. Claim 3, medical negligence, Maya Kowalski. 25, was Dr.
This is the med mal claim. Did they technically screw up in her treatment? This to me was the one claim that could have gone either way. You can believe Maya and still not quite get to the bar of medical malpractice because of how the laws are in Florida. But the false imprisonment and the battery were the huge ones, and the intentional infliction of emotional distress. Do they believe Maya? If the answer is yes, they should hammer the hospital, and that's what they did. Let's see if they just down the line said yes and how much they gave.
Dr. Sally Smith, an apparent agent of Johns Hopkins All Children's Hospital at the time and place of any treatment she provided to Maya Kowalski. Yes. 26. Was Dr. Sally Smith negligent in the medical care of Maya Kowalski? And was that negligence a legal cause of loss, injury, or damage to Maya Kowalski? Yes. 27. Excluding and not considering the conduct of Dr. Sally Smith, were one or more healthcare providers negligent in the medical care of Maya Kowalski at Johns Hopkins All Children's Hospital? And was their negligence a legal cause of loss, injury, or damage to Maya Kowalski? Yes.
So everybody, they're not going to be protected by the Sally Smith set-off from her settlement or the fact that she technically works for DCF. It's like Sally Smith and other doctors that work for Johns Hopkins, negligent, hammer 'em.
28. What is the total amount of Maya Kowalski's damages for lost earnings in the past, loss of earning capacity in the future, medical, psychological, and nursing care and treatment expenses to be incurred in the future? $4,700,000. 29. What is the total amount of Maya Kowalski's damages for pain and suffering, disability or physical impairment, mental anguish, inconvenience, aggravation of a disease or physical defect, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future? $22 million.
Huge
24.
numbers.
Fraudulent billing for Mr. Kowalski.
These are huge numbers. Huge numbers. Now, let's remember the fraudulent billing. They said you can leave a nominal amount for this, for him not be able to get insurance. You can put like $1 and we can figure it out later. Oh, they don't say $1.
30. Did All Children's Hospital fraudulently misrepresent a material matter in its invoices to Jack Kowalski or his insurers? Yes. 31. Did Jack Kowalski or his insurance company rely to their detriment on the fraudulent misrepresentation you found in answer to question 30? Yes. 32. What is the total amount of Jack Kowalski's damages for any deductibles or co-pays incurred as a result of Maya Kowalski's sheltering at Johns Hopkins, or increases in the cost of insurance coverage in the past or in the future, including increased premiums, co-pays, and higher deductibles? $3 million. 33. What is the total amount of Jack Kowalski?
That's a lot of dollars. $3 million. We're going to talk about appeals, but you better believe they're going to say there's no way in the world they should be able to award this much money on this claim. I disagree with them, but that's what they're going to argue.
These damages for the difficulty of finding insurance in the future. $2 million.
Total of
Claim
$5 million.
Survivor claim for the intentional infliction of emotional distress in the estate of Beata Kowalski. 34. Did Johns Hopkins All Children's Hospital, through the acts of its employees, engage in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Beata Kowalski prior to her death? Yes. 35. What is the total amount of Beata Kowalski's damages for pain and suffering or mental anguish caused by...
So now we're getting into what happened to her mom. Are they going to put the blame or a substantial portion of the blame on the hospital about what happened to Beata Kowalski and the decisions that she felt she was forced to make? Once that first one came back, yes. If you're sitting over there at that Johns Hopkins table, it is not going well.
The extreme emotional distress prior to her death on January 7, 2017, $3 million. Claim 6, wrongful death claim for intentional infliction of emotional distress causing death in the estate of Beata Kowalski. 36, the Johns Hopkins All Children's Hospital, through the acts of its employees, engage in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Beata Kowalski that was sufficient to be a legal cause of Beata Kowalski's death by suicide. Yes. 37, did the conduct that you found in question 36 create in Beata Kowalski an uncontrollable impulse to die by suicide? Yes. 38, was the conduct that you found in question 36 a substantial factor in Beata Kowalski's death by suicide? Yes. Question 39 addresses damages of the estate. What is the total amount of any damages sustained by the estate for loss of net accumulations? $653,676. Question 40 and 41 address damages of surviving spouse Jack Kowalski. 40, what is the amount of any damages sustained by Jack Kowalski for the loss of Beata Kowalski's support and services and funeral expenses resulting from Beata Kowalski's death paid by Jack Kowalski? $18 million. 41, what is the total amount of damages sustained by Jack Kowalski for the loss of his wife's companionship and protection and for his pain and suffering as a result of Beata Kowalski's death? $50 million.
Whoa.
Number 42, what is the total amount of damages sustained by Maya Kowalski?
That's $68 million for Jack Kowalski for the wrongful death of Beata Kowalski because of what the hospital did. That could set some precedent here in Florida. It really could.
For the loss of Beata Kowalski's support and services, $2 million. 43, what is the total amount of damages sustained by Maya Kowalski for the loss of parental companionship?
I missed that one.
Of Beata
Sorry.
Kowalski's support and services, $2 million. 43, what is the total amount of damages sustained by Maya Kowalski for the loss of parental companionship, instruction and guidance, and Maya Kowalski's pain and suffering as a result of Beata Kowalski's injury and death? $18 million. Question 44 and 45 address the survivor damages of Kyle Kowalski. 44, what is the total amount of damages sustained by Kyle Kowalski for the loss of Beata Kowalski's support and services? $2 million. 45, what is the total amount of damages sustained by Kyle Kowalski for the loss of parental companionship, instruction, and guidance, and Kyle Kowalski's pain and suffering as a result of Beata Kowalski's injury and death? $18 million. Claim 7, intentional infliction of emotional distress, Maya Kowalski. 46, the Johns Hopkins All Children's Hospital, where the acts of its employees engage in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Maya Kowalski? Yes. 47, what is the total amount of Maya Kowalski's damages for lost earnings in the past, loss of earning capacity in the future, medical expenses incurred in the past, and medical expenses to be incurred in the future? $3 million. 48, what is the total amount of Maya Kowalski's damages for pain and suffering, disability or physical impairment, mental anguish, inconvenience, aggravation of a disease or physical defect, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future? $7,500,000. So say we all, this 9th day of November, 2023, 4%.
Hand me back the verdict form, please. Do the attorneys wish to inspect the verdict form?
All right.
Please come.
So they poll the jury. Everybody says this is their verdict. They inspect the verdict form. Everybody or nobody has a problem with it. Obviously, the plaintiffs aren't going to. By my count, I got $210.5 million. I easily could have missed a couple million here or a couple million there. But what does this mean and why is it important? Okay. $210.5 million. Of that, the punitive portion, $26 million we talked about for false imprisonment, $31 million for battery is $57 million. There's no doubt in my mind if they would have put the punies on intentional infliction of emotional distress, the jury would have said yes. So we'd have at least another 10.5, maybe even a portion of that wrongful death claim on there. But if we're looking at $57 million, that could be a portion to the punitive damages. That's 171. I'm sure you guys told me if my math is wrong. 171 million under Florida's normal statute, which is 3 times compensatory damages that they would be capped at. If they gave 210 million for this, my guess is they want to give a lot of money for the punishment and punitive damages. Freelance asked, what is punitive damages? Punitive damages are in place to punish wrongdoing and deter similar conduct. So if they see a big hospital or big corporation treating people horribly, abusing people, falsely imprisoning people, intending to inflict emotional distress, just think about that. The question they want to ask on the punitive damage side is specific intent. They've already said they've intended to cause emotional distress. They've already found that. I would be shocked if they did not answer yes to that question, that there was a specific intent to hurt Maya and her family, and their actions resulted in harm for them. Vicky K, they have to make it hurt. And as a nurse, it will set standards across the board. I agree with you. It will. Anna P, no amount of money can replace a mother. It won't rectify the missed birthdays, weddings, daily memories Maya and her family won't have. I pray Maya and her family have some closure. Her mom would be happy to know she got justice. Yes. And regardless of what we feel at this point, right? Regardless of what if anybody in the chat feels about how this happened, the series of events, the decisions people made, this jury, after listening to 8 or 9 weeks of evidence and arguments, they said all of this stuff Anna P just said, all of this is Johns Hopkins All Children's Hospital's fault. That's what they said. It's their fault. We're not splitting percentages. We're not saying she would have probably already had some pain and suffering, because what they did to her made it so much worse. It doesn't matter that she walked in there as a sick kid. She walked out, and like her lawyer said in closing argument, they blew up this family. Nobody knows why. Kay Baker, will the hospital have the money to pay this, or how will they get it? Good question. They definitely don't have this kind of insurance, would be my guess. But we're going to hear a little bit about the value and the profits that this hospital has potentially to pay this money out of. But Chica asks a good question. Do I think they will appeal? Absolutely. I think they will appeal. Whether they'll be successful or not, I don't know. I think if I had to guess what's going to happen, I think they're going to appeal. I think they'll probably have some decent arguments. Any 9-week trial will. And I think they end up, what I said at the beginning of the trial is I'd be willing to bet Johns Hopkins made offers and made big offers. But the plaintiffs wanted to go tell their story, get somebody to believe them, publicize it so the world can see what Johns Hopkins did to Maya, get a huge number, because it's a lot easier to ask this hospital for $100 million check, which is real cash money in the bank. It's a lot easier to ask for $100 million if you have a $210 million verdict. Because asking anybody for $100 million, they're going to say no. It's going to be tough to prove that. They may have offered, I don't know, let's just use their numbers. They may have offered $1.5 million per person, $4.5 million, $5 million, maybe $10 million, whatever. These are the numbers their lawyer was throwing out in closing argument. That's probably the numbers they offered this family, which is real money and a lot of money. Life-changing money. But it's not $100 million. And if the plaintiffs and their lawyers thought it was worth $100 million, this will take you a long way towards getting real value for this case, because guess what? A jury agrees. Now, there's bankruptcy. They could file bankruptcy, all these issues that, we're not going to talk about on today's video, but it will absolutely be appealed, and we'll see if it ever gets paid. Judicial Mermaid. Is this the largest in possible punitive damages that Johns Hopkins has faced? This is huge in setting precedent when it comes to minors, parental consent, and standard of care civil suits. There is so much going on behind the scenes and so much leading up to this that I think this is going to set a lot of good precedent. But I do think that with any major eye-opening and jarring, that's what this is. This is a jarring verdict for the claims. This is not, you cut off the wrong leg, med-mal case, or you gave the wrong medicine and somebody died. Those are huge claims. Those are real claims. People's lives are changed forever. People die. There was so much more to this. Individual bad actors, failure to report, DCF's involvement, Sally Smith, Catherine Beatty, nurses, doctors, CEOs, the culture there that they talked about. And by the way, speaking of the culture, I wanted to give a compliment to this chat. You guys would be surprised, as I am. I am very surprised at who watches these videos. And they don't just watch the videos. They also take a look at the chat. And they said, it's amazing the community you have there. And the way the chat discusses things, how thoughtful they are, how respectful they are, even if they disagree. How you encourage them to ask questions that maybe you don't know the answer to, maybe you agree, maybe you don't agree, and how the chat keeps flowing. And it's like a positive chat. It's a constructive chat, right? It's not always good or happy, but it's a constructive chat. And I will just say, not just this case, but across, I have gotten some crazy messages in the last couple weeks. I mean, we had Mark Eiglarsh on after covering a trial that he did, but I am very surprised at who watches this, and doesn't change the way we do anything, because we always try to be respectful, whether or not we agree or disagree with a witness or with a lawyer or a judge or a doctor or whatever it may be. People are asking if I'm covering phase 2. Yes. But I don't think we're going to watch it on here. No, Complex Lit. It's not other YouTubers. It's not other YouTubers. Marshmallow. I'm so glad I finally caught alive in this case. I'm so glad that the jury believed Maya and her family. Hopefully this will lead to the much needed changes in the medical industry. I agree. I agree. People are saying the defendants are sore losers. Oh, stuff's happening right now. Let's pop into court and see what's happening real quick as they get ready for phase 2.
Why it would matter, but I recognize the objection.
Are we going to be allowed to put on the evidence we need for that question?
You're going to be able to put the evidence that you wish to put on. Mr. Cottrell's coming back, I see. Actually, I need plaintiff's lawyers. I mean, Ms. Lawrence is here. Finish with your.
Yes, sir. Yes, Your Honor. I'm back in Tampa, although I'm having some computer problems, so I'm still on my phone.
Oops, I probably on the wrong setting, Mr. Reyes. I'm just trying to get everything up so that were circulated approximately 12:45 today.
I have received them, but I can't access them right now because of having a computer problem. But I think it was what we looked at before, with just adding that other question in, wasn't it?
Well, I added a little extra language.
Oh, okay. I saw that you had sent something.
Is there someone in your office that can print it out or somehow bring it?
That's a good idea.
Or bring you a device?
Oh, wait, here. I think I'm, okay. Oh, I'm back in. Okay, hold on. Let's see. Let me open your draft. We're talking about the verdict form right now?
We probably should start with the instructions and then go to the verdict form.
Okay. I'm opening those now.
TV folks have access.
Clear and convincing or very white. Are there any questions that match up on the verdict form to that?
What's funny, if I was the plaintiff's lawyer right now, I would say, Judge, go ahead and put in there, do you find specific intent by clear and convincing evidence? I wouldn't even make the argument, just in case you're wrong and it sounds like greater weight of the evidence. Say, Judge, we as the plaintiff's lawyer, we agree. Put in clear and convincing evidence because we think we can convince this jury by clear and convincing evidence they had specific intent to harm her. I would be fully confident at this point in this jury. It's the same jury making these decisions.
Yes. Mr. Altenburn, do you have?
I have this open on my phone. I have not just came in about the same time I started traveling. So.
Do you want me to? I can just print out another copy and I can
I
give.
understand what you did, and first I'm going to object as vigorously as I can to the fact that we are now having the jury answer a phase 1 question by clear and convincing evidence that I had no notice of until this morning. We didn't have a chance to defend against it. We've had no chance to argue against it. It should have been in the phase 1 instructions, and now you're going to intermingle the phase 1 and phase 2 instructions when we wanted a bifurcated proceeding. So I object vigorously to the second question being on this form.
He objects vigorously. So, and kind of what I'm thinking as just we're going, right? This isn't my case. The fact that they found intentional infliction of emotional distress and clear and convincing evidence on punitives on the other two that even allowed punitives, I think there's already an argument that they found that there was intent, specific intent here necessary to bust the cap. But the question would be great. And again, if there's something legally improper about putting the question in phase 2, then they can deal with that afterwards and the judge can strike it. But we need to know what this jury actually thought. It makes no logical sense to not get this answer while we have this jury here now. Makes no sense.
Doesn't the standard jury instruction have this in the phase 2?
No, there is no standard jury instruction whatsoever on the specific intent question. And the only case that I can find, and I think that Mr. Elliott has found, is a case that put it in the phase 1 instructions.
Mr. Elliott, anything you'd like to say?
All right. I don't have a case in front of me. That's the Longwood case. That's the case, isn't it?
It's the Longwood case. It doesn't discuss it, but footnote 10 quotes the instruction, and that instruction was given in phase 1 because it's not an instruction on damages. It's an instruction on the substantive elements that are going towards punitive damages, and that has to be tried during the case and presented in phase 1, not in phase 2.
Mr. Elliott, any response?
Your Honor, I think they're going to answer it now. I don't think Longwood to say that's where it has to go. That's just the way it's done there, and there was not a lot of law. So I think, I assume they want that asked, and it should be asked here.
As a due process matter, we were entitled to notice of this and opportunity to defend it and to have it on the first verdict form.
Well,
yeah,
here's
because
what,
they for sure did not try to defend that they didn't have any specific intent to harm Maya. They never tried to prove that during the trial, ever. They would have done loads of things differently. It's like, do we need a playback closing argument where you said, this is Johns Hopkins All Children's Hospital? They loved Maya. They tried to help Maya. They played music with Maya. They braided her hair. They were not mean, nasty people. They liked Maya. That's arguing against the fact that they had specific intent to harm Maya. They even said, putting a kid on your lap, what's the big deal? That doesn't rise to the level of battery. And again, I think that's a good legal argument. but the jury didn't buy it. You did argue against specific intent. You maybe didn't use those exact words, but you absolutely argued against specific intent. There's not a due process issue here. I would be shocked if Judge Carroll did not allow this question on the verdict form. We have the jury here making the decision. Let's find out what they thought. Because a lot of times this case law develops and it's like, well, do we think the jury found specific intent? It's like, without this specific question, how do we know?
What we're going to do, I'm going to allow the question to go, especially since, when I say go, it'll go to the jury, especially since section 768.73 paren 4 prohibits us from telling them why we're asking them the question, which is basically whether or not the punitive damage cap applies or can be avoided. And since we don't tell them why we're asking them the question, I don't see, it's the same evidence between phase 1 and phase 2. There's a little extra evidence in phase 2, so I'm not exactly sure why it would matter, but I recognize the objection.
Are we going to be allowed to put on the evidence we need for that question?
You're going to be able to put the evidence that you wish to put on. Mr. Cottrell's coming back, I see.
But to be clear, we were not preparing anything to put on for this particular issue until we received notice this morning that they wanted to do it this way.
Well,
So we're having a trial with, what, 4 hours notice or something like that on an issue that should have been tried throughout the trial from the very beginning.
I understand your objection, and this is how we're going to proceed.
Okay.
And I to be as clear as I can,
They're not happy about it. And again, cut them some slack. I wouldn't be happy about it if the roles were reversed. Okay. Lawyers do not like things sprung on them, but they are trial lawyers, at least some of them in the room, and they will be able to adapt and deal with it. And I don't mean any offense by that. Some of them are appellate lawyers or, whatever, have other specialties. Nirvana, Beata and her family made whole today. To see the good in this world gives me hope for our country. Thank you for your coverage of this case and giving heart to the process. Rest in heaven, Beata Kowalski. Yeah, because these are American people. 6 random citizens are looking at that hospital being like, do not treat normal people like this. Jane B. Peter, we love your show and videos. My husband is not feeling well today and he is in bed watching you live. Thank you for a great job. Well done. Jane B, thank you so much for this super chat. And Mr. Jane B, get well soon, man. But luckily you've got something to keep the mind going while the body might not be feeling great, right? And we're going to continue to pick this apart here and see what we can learn. We're going to go as long as we can.
Mr. Altenburn has preserved this issue for appellate purposes, and if we need to address it post trial motions, we can definitely readdress it then. But
it's like if you're going to err on the side, right? And you're like, I'm not sure if the question should be there or not. Let's just say the question's not there. And then you're like, oh, shoot, we should have had it. And now we don't know the answer versus let's put the question in. And if it shouldn't have been there all along, then they don't get to ask it. And now punitives are capped. Just makes sense.
I'm going to get the finding from the jury as to what they are thinking. So with respect to the instructions, Mr. Altenburn had a slight change to go to when you determine. Any problem with that, Mr. Elegant? On the second line?
Let me get back to them. I'm sorry. I flipped over the first thing. Let's see. If you can read Jimmy, I probably don't. I'm just having trouble calling you up here.
Well, currently it reads, members of the jury, I am now going to tell you about the rules of law that apply to determining whether. And Mr. Altenburn suggested tell you about the rules of law when you determine whether.
So that's fine.
That apply when you determine what.
That apply. Yeah, absolutely. I apologize for not saying that word. I'm just going to make the change here so I don't forget it.
And they're changing this stuff on the fly. Got to get it right for appellate issues. Matt Bond said this case has already changed how my pain specialist treats me in Australia. Around the world.
The next is at the end of that paragraph
changing things,
where it talks about should decide any disputed factual issues. When it currently talks about by the greater weight of the evidence, I added or by clear and convincing evidence as specifically indicated on the verdict form. So it will reference both standards and then define both greater weight of the evidence and clear and convincing evidence. That's my recommendation.
And I think that is consistent with our.
It will reference both standards and then define both greater weight of the evidence and clear and convincing evidence. That's my recommendation.
Yeah, I agree. I agree with it. If I was the plaintiff's lawyer, I'd be like, yes, sir, go ahead. Tell them beyond a reasonable doubt at this point, right? Now I'm being facetious there, but I mean, I think this jury is locked in with the plaintiffs. I think they believe Maya and her family. MC, can you explain why they're arguing this? They're trying to get the jury instructions right for the punitive damages so that the jury can know what they're deciding and how much to put in there. Joanne, sorry started late, so I'm a bit behind. Do you think the immediate jeopardy report was the biggest factor for Maya? I do not think it was the biggest factor for Maya. As in most cases, I think the biggest factor for Maya was Maya. and her testimony, and I think they believed her. Terry, can Kathy Beatty and or Sally Smith now be held criminally responsible for what they did to Maya and her family? Thanks for covering. Unlikely, but I guess it's possible. I don't know. I don't have all the dates in my head. I don't know if statute limitations have passed. It would be unlikely, but possible. And as you heard, the greater weight of the evidence or even clear and convincing evidence is a much lower burden than beyond a reasonable doubt, which is the criminal standard. So that comes into play in things in situations like this as well. Desert Quill. Parents only consented to leave Maya in the hospital so she would not be put in a psych ward or foster care. The consent didn't count. Yeah, the jury definitely didn't see it as consent. Have they said the amount yet? Abnormally, Carolyn? Yes, it's over $200 million, somewhere between $210 and $230 million. Not quite to the $238 million, but I think everybody on the plaintiff side is very happy. Laura G, I'm behind, but those are tears of relief from finally being validated. That kind of relief is like no other. As one who lost my mother while young, my heart is with her. I can't imagine the relief that they must feel.
And I think that is consistent with our effort to have questions that will answer this one way or the other, depending on legal rules later.
Mr. Altenberg.
Well,
No, knowing
my prior objections could have been overruled. I guess that goes with what you want to do. So I can't stop.
Right. And again, I know you are objecting to having the specific intent question on the verdict form.
Yes. And anything and everything that relates to it. Yes.
And I also know that you are suggesting that the specific intent has to be a clear and convincing evidence finding. And I'm actually leaning in your camp on that but that's why I didn't quite know, because the case law doesn't really say whether it is clear and convincing or greater weight.
There's very little case law, but it lines up as a finding on something that is a predicate to being entitled to damages, which means it's a finding of fact on a substantive matter for which clear and convincing evidence was necessary during the trial and during the first verdict.
So I will add the language that I proposed on page 1. Now,
Judge is like,
Mr.
thank
Altenberg,
you.
on page, I guess it's technically page 3, A, 1, 2, and 3, you had some comments.
And I've taken those out. That's all right.
Okay, so is the language okay as it's circulated, where one has whether the wrongful conduct was motivated solely by unreasonable financial gain?
Yes.
And so we're leaving that in?
Right. I mean, I believe there's no evidence of that, but I think they have to know that they're supposed to have that to do this. So yes.
I haven't had a chance to talk to the trial team on that. I guess I would ask Nick or whoever's there. I mean, if we want that in.
We need a question.
Okay.
Well, no, hang on. No. I didn't mean it that way. We're wondering what the question is.
Well, the question is, does A1, whether the wrongful conduct was motivated solely by unreasonable financial gain, should that be a question, an instruction in the verdict?
So we talked about this, right? If you listen to the punitive damages discussion that we had with the case law, it's unreasonable financial gain is one of the ways that you can get it from 3 times compensatory damages to 4 times compensatory damages, but that doesn't really fit for this case. So I don't see that. Maybe they will put it in there because I think the jury's kind of saying yes to everything at this point. I don't think there was a lot of evidence put on for that, but the specific intent one that they do want, which busts the cap altogether, it doesn't make it 4 times, doesn't make it 5 times, makes it whatever you want. There is no cap now. And again, the defense lawyers are fighting vehemently against this. Ashley, this is really unusual stuff. We're in some uncharted territory here with these types of claims and how this works. Yes, Nina, 7,000 in the chat. Hit that like button. I don't think I've said this yet. Hit the like button if you haven't already. Subscribe to our page if you haven't already. Thank you so much. April, I know misdiagnosis happened for 2 years to me. Leg blood clot in my leg and multiple PEs. No one believed me and they could have killed me. Now I have permanent leg damage that even painkillers don't help. I think it's important to always remind everyone how important the medical field is, and doctors that are there are supposed to be helping people, acting reasonably, doing what's best for them. And this case is definitely going to shine a light on that.
Verdict form, and in the instructions, and then I assume there's a question on the verdict form that corresponds.
There's not a question on the verdict form.
I don't understand why we would need that.
Because it's
Yeah,
not
I don't think that's
applicable.
the contention. So I think maybe one can come out. A1 can come out.
Yeah, I think we're talking about, I confess to being a bit behind schedule here on where we're going to insert such a thing.
Mr. Altenburn is suggesting that number 1, which would require the wrongful conduct was motivated solely by unreasonable financial gain, that isn't something that we need to instruct on because that wasn't the theme of the case.
Agreed.
I agree. The financial gain was just not a main point of the case. And Kat, thank you for saying this. Tons of great doctors and nurses, and they don't really have to worry about this. It's the bad ones that should worry about it.
But let me check with my trial counsel because they didn't prove it. It's not an issue. And if that's normally a factor, we ought to be able to point out that's not why we did it. So I don't know how you
I agree with
think
the
it's a
defense
factor
here.
in the sense of it gets you, it's another cap alternative that we're not asserting.
Yeah, but for some strange reason, it's in the standard form as if you give it every time. And so, I mean, I don't think there's proof of issue 1 or issue 2 on that form, which is why I question whether they should be there. Let me, if you don't mind, can I?
No, you can ask, absolutely. Would it help if I just had my assistant print out a couple paper copies?
That would help the trial team tremendously.
Yeah, I see it. It is in, I do see that it's in C2 subpart A, but I think, let's see if there's an instruction.
They're actually
Okay,
arguing over just
I'm
the
looking at
jury
the note on
instructions.
page-
What are they going to tell the jury that they're here to decide? What decisions can the jury make? What can't they make? Can they get around punitive damage caps?
5, in the printed version, it's, I guess that doesn't matter, but it says instruction 503.1 C2.
Right now, we don't know what you're allowed. Open statement, closing argument.
Sure, you get opening statement.
We like leaving them.
So, Ms. Syback, go ahead and print what I just forwarded you, 4 copies, please, and bring it in. Okay, well, I'll go ahead and leave it in right this second. I then added, you may in your discretion decline to assess punitive damages. That seemed to be as a standard that the prior version didn't have.
That's right. It's supposed to have been in there. It just wasn't put in there. That's in the
So you're okay with me adding that?
Yes, I had added precisely the same language. in what I said.
And
Yes, plaintiffs are okay too, because that is in standards.
okay, I think that was the balance of the issues in the instructions. Let's go over to the verdict form. And hopefully my assistant will bring this in just a moment. Do you have the verdict form there? Rottenberg, are you going to be fine? Okay, so from a conceptual basis, what I did is the question number 1 is the damage question. And I think that comes from the standard, and I don't think there's any objection to that. And then following the damage question, there are 2 additional questions, which is the specific intent question. The first specific intent question would be to clear and convincing evidence. And then if they answer no to that, then it directs them to go to the greater weight. So we would know by what quantum if the jury were to conclude that there was a specific intent of harm. Now, I know this is over the defense's objection and they don't want it, and I'm saying we're going to have it. So under those
It's
circumstances,
got to be really, really bad by a higher standard, specifically intending to do this harm. We got to make sure they really want to hammer them if we're going to get around that cap.
Mr. Altenburn.
Given the prior rules, this is consistent with
But how it's framed, doing the clear and convincing evidence standard, and then going to the greater weight.
if it's on this one, that's probably that.
Mr. Elegant,
Agreed, Your Honor.
are there other matters within the verdict form that we need to address?
Yeah, yes, Your Honor. And actually, in fact, the jury instructions as well, now that I'm looking at it, we had discussed combining January 6th into one. Somewhat, I guess since I'm objecting to this, the clear and convincing part of this, it might as well be combined for the 2 of them. It's easier to combine the 2 of them than it is to try to explain non-duplication to a jury that hasn't been avoiding
It doesn't really matter. I mean, we're going to talk numbers anyways, but whatever.
non-duplication in the first half of this. So I just assume have them combined by you.
So what
I
Mr.
can take issue with that, but
Well, Mr. Elegant, the concept here is
I can understand.
for the photography session, just ask, combine the false imprisonment and battery.
I returned to my trial counsel. They're okay with that. I mean, I see the logical sense, and it's the same thing.
Just find the questions.
The 2 January 6th, yes.
Yes.
Okay. That sounds good. And then we avoid non-duplication if we're identifying. My comment was I wasn't agreeing that they had, the jury had disregarded them as far as duplication goes.
Okay, so what question 7 will read, at the top, it says claim 1C and claim 2, false imprisonment and battery, January 6, 2017. Question 7, what is the total amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against Johns Hopkins All Children's Hospital for the false imprisonment and battery of Maya Kowalski occurring on January 6, 2017?
So there's combining those up. So there's not duplication. But again, this only really matters if there's a cap. If there's no cap, they can give as much as they want basically for that, whether it's 2 incidents or 1. And it just can't give duplicative damage amounts for punitive damages. But It's probably getting into the weeds a little bit too much. Will this case, it's my kid's personal Uber driver, will this case break Florida records, and does the family pay taxes on this money? My guess is this is going to be the biggest Florida verdict this year. I don't know the answer to that yet, and we'll see a little bit more. I want to say last year or 2 years ago, there was a $1 billion verdict in a trucking death case that I think was $100 million and then $900 million in punitives, $100 million in compensatory. I could be getting those numbers wrong, but it was the president of the FJA at the time, Curry Padgett, I think that tried the case. Peter, do you think the Kowalskis will go through appeal or settle? I think they should settle if they get, over $100 million, but who am I to tell them to settle? I think they should do what they think is right and just and fair for them. I think they've been through a lot. I think $100 million is probably more money than you can spend. And if they can move on with their life, they got their day in court, they got their justice, the jury believed them, but maybe they'll get more. Maybe they'll get 200, maybe they'll get 300. I hope they get as much as they possibly can for what they went through.
I think that's a correct combination.
Agreed.
And so that means the verdict form will only go to question 9. So I got to change the instruction.
Settlements are different than verdicts.
And I am doing that as we I will recirculate I consolidated the false imprisonment and battery for the photo session that I didn't mess it up. So, now, Mr. Altenberg, you said that there needs to be a change to the jury object, and I know you've preserved that. And Mr. Altenberg, knowing that I am going to allow the specific intent questions, I know you object, and I know you've preserved that. And
I don't believe I have any other objections to the form.
okay, that's my question is there any other change to the language other than the fact that we are going to have the specific intent questions?
No, Your Honor.
Mr. Elliott, any other?
No, Your Honor.
Okay, so what I'm going to do, let me just send this real quick.
Thank you, Netwoman. No question. Yet.
Attach the documents. Members of the media who've been asking, the clerk of court has already processed the verdict form and it is now published on the clerk of court's website.
Wow,
at
that was
docket
quick.
Identification number, or DIN, DIN 3629. That's the docket entry, the 3629.
Wow.
It's on the clerk of court's webpage now. You can grab it there.
It's a little special treatment.
Your Honor, I received your email.
Did I have attachments on it, or did I forget to put
Yeah,
it?
nope, the attachments are both there.
Okay, great. So you'll have a couple minutes to look at that. Let's talk about the proceedings. How much time does each side wish for opening statements?
Yeah, I don't think I need more than 15, 20 minutes. But do that.
15, 20 minutes, fine.
So each side will get 20 minutes for opening statement. And is there anything other than we're now in the round 2 that you want me to tell the jury before we start?
Sounds good.
Is there anything else you want me to tell the jury other than we're in the second round of this trial?
We have some exhibits we'd like to admit.
Let's deal with
Could I first judge ask what you want to perceive as the scope of what we're doing now, Tom? You shut up for something.
my understanding was each side.
Thank you for your coverage of this trial and the safe space to be able to voice our opinions. May this set a huge precedent across the board so others think twice before abusing their power. Misty, could not agree more. It's literally what we do as personal injury lawyers, David versus Goliath type stuff, fighting the man and the big companies and the government and the corporations that sometimes just think they can step on people and nobody's going to say anything. But this was a big one. Thank you, John. Just keep growing the membership pool. Before tomorrow, 10 a.m. is our members only live.
Was talking about 90 minutes or so.
What we're trying to do within 60 to 90 minutes, close to 60 if at all possible. We want to get out of here. We're waiting for Mr. Pease. He should be here though.
We'll give you that time you're done for openings.
Yeah, he should be.
And so they say they want 60 to 90 minutes. How much does the defense wish?
That's what I'm doing. Can I close it?
I'll go close it.
Just 30 minutes aside, enough for each side.
Yeah.
That's fine, Joe.
Does that approach it?
So what we'll do, 20 minutes for opening, up to 90 minutes for case in chief and any rebuttal, and 30 minutes closing. How many exhibits are we talking about?
We're talking about 8 to 12.
And let's go.
By the way, that's about 5 hours, which would mean we're not going to finish today, would be my guess, unless they're planning on going really late. But that's 5 hours of punitive damage evidence and argument.
With Roman,
That approach?
sure.
Started a
That's
trend,
it's been
John.
handed out.
I'm going to right now.
Thank you, Donna.
9 needs to be January 6th, 2017, sorry.
Made that change. Or are these financials?
Yes, Your Honor, and we could proceed with what's labeled as 2279H and J, which are the most recent tax returns for Johns Hopkins Children's Hospital. The two
So now we start to see behind the curtain a little bit in punitive damages, and to publicize this is just wild. But they're just going to go into all the financials, how much money they have, how much they make, tax returns, how much money we want to really hammer them. Some of this stuff is probably public. I don't know. But this is wild. Net Woman, thank you so much for continuing to grow the community that so many people compliment to me privately.
two previous ones that Charlie and Delta are there, so we don't face an argument that we're not using the financials from the relevant time period. There was a deposition yesterday of our punitive damages expert where it seemed to be stipulated that we'd be referencing the most recent tax returns. So long as that's the case, we don't need 2279 Charlie or Delta.
Yeah, can I have a copy, please, of whichever is 2279J?
We can put it up.
You know, or just send it to places you print it, please.
It was provided by Mr. Hunter about in mid-September.
Oh, the one we talked about with Mr. Keith,
No, you were talking about the fiscal year 21, but
Right.
we went back and looked and saw that fiscal year 22 was provided mid-trial.
got it, okay. Yeah, just want to make sure we're working off the same document.
So what is the position of the defense on 2279H and J?
Yeah, I have no objection if those are the documents that are going to go off.
Okay, the court receives 2279H and J. Do you have those documents in your possession?
It is. You can send them out.
Yeah, we'll need to print these as, I mean,
Yeah, we're gonna need them. Okay, so I've received 2279H and J. What's,
all right, Your Honor, from there, we'd like to proceed with 2828 and 2829 on the same proviso that if we're not going to be required, there's going to be a appellate issue about not having the 16 and 17, and we don't need 2826 or 27.
sorry,
Mr. Whitney, I apologize.
That's okay. 2828 is what's been called the audited financial statements for 2021. 2829 is what we've been told were the audited financial statements for 2022.
Yeah, my only objection, Your Honor, is when we took Mr. Keith's deposition yesterday, I asked him what documents we're going to rely on. And he said, I'm only going to rely on the ACH Form 990 from 2021. He said, if I get
Not only this, only plans sticker shop, but he also, when he asked if this was his verdict, I feel like I could tell which one was him when he said yes. Like he was proud of this verdict. Nick M, I mean, always arbitrary caps happen all the time. They're always trying to push down how much somebody can possibly pay for something. And what I say is, don't do that then. Don't abuse a 10-year-old girl. Don't falsely imprison her. Don't pin her down. Don't take pictures of her. And then you won't have to worry about numbers this big. Donna, thank you for another gifted membership.
updated, the tax return 990s contains somewhat similar information, but based on the representation you made to me yesterday, for surprise, I would like them to be limited to the tax form that I'm prepared to cross them.
is there evidence still in the jury room? Yes. Okay. Any problem with the clerk going to get the actual evidence from the jury room?
What hospital? Scheduled for 1 p.m. We had asked for 9 a.m. So it didn't happen.
Well, that's unfair, Mr. Whitney. You asked for either 9 a.m. or 1 p.m. and I gave you 1 p.m. So please don't
We gave the option. So here we are without a deposition of the CFO. We would move to admit.
Look, these are audited financial statements. I mean, are they audited financial
Yeah, I'm
statements?
sure they are. I'm not questioning the authenticity. It's surprise testimony. That's why I take a deposition.
I will receive into evidence the audited financial statements 28, 28, and 28, 29. Now, on the specific issue, Mr.
So this is what the defense does sometimes. They block your ability to get stuff. And then when you do get stuff, they say it's late. It's like, well, we could have had this stuff by deposition that we offered to you, but you didn't let us take the deposition. And the judge smirk tells it all.
Shapiro, Mr. Whitney didn't put in the 2016 and 2017 financials because of this discussion that y'all were going to rely on the most recent. I just want to make sure that you agree with that.
Yes, sir.
Okay. What's next, Mr. Whitney?
Your Honor, we'd like the court to consider admission of 2451, which is Catherine Beatty's arrest record.
That's still not allowed to come in.
Ouch.
So no.
Yeah.
What's next?
Hunter popped up.
We would
Oh,
like
did you see
to-
that? He's like, give me that.
So no. What's next?
Give me that.
We would like to play for the jury sworn testimony by Catherine Beatty regarding her cooperation with Sally Smith in other cases.
Let me hear what this is.
And this is 2758 Delta.
It's for the dependency action.
Yeah, let me just hear it, but let me understand the context and then we'll go from there.
It should be your auto clip there, 2758 Delta. Do you have it?
Looks like it's 46 seconds.
It's 30, page and line. 36, 26, 37, 14. We're gonna move past that one. Let's proceed to, do you have 2830, the video?
The greater weight,
Yeah, that's in there. I added that.
you're gonna do both options?
On the verdict form?
Yes.
Yes, that's what we talked about, that the,
Oh, I did not understand. I thought for heaven's sakes, you were gonna still use clear and convincing evidence, which has gotta be the finding on that. It can't be by, it's not a damage element, it's a substantive element to allow for damage.
which is why the question says something along the lines of, based on clear and convincing evidence, do you find, or something like,
Yes, but then it's followed by one that says greater weight of the evidence. You're giving a pair each time.
correct, because I'm not sure if, I think you're right.
This is like the causation thing. You don't know what the law is, so you're gonna give the jury both options right now? Is that what you're gonna do? I'm sorry, I object to that. I have to.
Oh my gosh. Whoa. I mean, well, what are you doing? Being disrespectful, I'll just tell you. Carroll's not going to care. And he also, I'll just tell you, he realizes, like, this is like, for an analogy, a lot of people like, think about your favorite sports team. When they lose 50-0 and somebody comes and tells you, like, hey, did you get the score of that game? And they tell you, and they're like, can we watch it back? You know they're going to be in a bad mood when you talk about that game. Well, Johns Hopkins just lost $200 million to 0. So Judge Carroll's going to understand tensions are high. People are mad. He doesn't mean to be disrespectful. He's got clients. Clients are not going to be happy. They hired these lawyers, paid them good money. My guess is the lawyers told them this was not going to go well because defense lawyers know how this stuff works. Just FYI, they're probably not surprised, if you want my opinion. I don't think there's a lot of shock in the courtroom from the lawyers. But gosh, I mean, that's just, it's disrespectful. It's not great to see. But I feel his pain. If you get smoked like this, you're not going to be happy. And Judge Carroll gets it.
Well, Mr. Altenburn, because the law isn't as clear as we need it to be, I am giving both variants. I'm going first with the clear and convincing evidence. And if they find by clear and convincing evidence the specific intent, they will not answer the greater weight. If they answer no to the clear and convincing, then I'm going to ask to the greater weight of the evidence. That way, it gives us the maximum flexibility to address it. And then when and if this goes up to the appellate court, it gives the appellate court.
People said play again. So we'll hear him.
Lines up based on clear and convincing evidence.
Here's the point. The question is, just to make sure everybody understands, the question is, to get this specific intent to bust the caps completely, does it have to be by clear and convincing evidence or by the greater weight of the evidence? They're not sure. So the way the judge did it is first clear and convincing, because if they say yes to that, then obviously it would be getting over the greater weight of the evidence. But if they say no, well, now let's ask, what about the greater weight of the evidence? Lawyers make a big deal about this. That's why I talked to my buddy the other day that was on the jury. I love to talk to jurors. How much do you think about the burden? Or do you just think who won? Who proved their case? Because lawyers make a huge deal about greater weight of the evidence, 51%, clear and convincing, but beyond a reasonable doubt. And it's like, do jurors really think that? I would almost, it's risky, but as the plaintiff's lawyer in this case, I'd be feeling so confident right now. I'd say, get rid of the greater weight of the evidence, judge. Just leave clear and convincing evidence on there. We've already proved multiple things by clear and convincing evidence to them. I'd be very confident we can prove this by clear and convincing evidence. Leave it just as that and let's go. Let's party. So here's this defense lawyer is not happy about putting both on there. And he basically calls the judge an idiot and that the judge is just like playing backyard football at this point.
Find or something like that.
Yes, but then it's followed by one that says greater weight of the evidence. You're giving a pair each time.
Correct, because I'm not sure if, I think you're right.
This is like the causation thing. You don't know what the law is, so you're going to give the jury both options right now? Is that what you're going to do? I'm sorry, I object to that. I have to.
Is this like the causation thing? You don't know the law, so you're just going to put both on there? It's like, whoa.
Okay. Well, Mr. Altenburn, because the law isn't as clear as we need it to be, I am giving both variants. I'm going first with the clear and convincing evidence. And if they find by clear and convincing evidence the specific intent, they will not answer the greater weight. If they answer no to the clear and convincing, then I'm going to ask to the greater weight of the evidence. That way, it gives us the maximum flexibility to address it. And then when and if this goes up to the appellate court, it gives the appellate court the maximum flexibility. I would hate to say it's clear and convincing, and then the second tells me, no, Judge Carroll, it's greater weight, and I got to do this whole thing over when I can just ask one more question.
This whole thing is to make unlimited punitive damages against my client. So I object to all of this. The record's clear.
I know you vociferously object. Okay, Mr. Whitney, are you ready on your clips?
We are ready with the.
Oh, I need to flip the control. Okay, I flip the control. It's just one button. I can do it.
Video statement by the current president of Johns Hopkins Children's Hospital, Alicia Schulhoff. 1 minute, 2 seconds.
Okay, let's play it.
Flip the audio because I had it on Zoom. Just a moment. My apologies.
trial regarding care we provided to a patient in 2016. We anticipate that the jury will begin deliberating in the coming days. We don't really know how long they will deliberate, but you may hear the verdict before we're able to communicate with you directly. Please know that given the nature of this case, any decision will be complex and will take time for us to fully analyze. As a nurse, I've been doing this for a very long time, and I've seen a lot in my career. And I want you to know that I have never been more confident of anything. More confident that the care we provided to this patient was exceptional, compassionate, lawful, and life-saving.
This case has attracted substantial attention in the media, and much of it has been wrong. What has been made clear in court is that our team of providers did something both heroic and yet for us commonplace.
Judge.
So that's Johns Hopkins right now while the jury was out saying that. If the jury hears that, what do you think they're going to think? Because they made a very clear statement that they believe Maya. They want to hammer Johns Hopkins. If I'm making an argument in punitive damage, I would say they still don't get it. They don't freaking get it. That's what Anderson said in his closing. They don't freaking get it. Holy cow. They just said that. So how do you feel about taking your kid to Johns Hopkins? If that's still how they feel right now, that it was exceptional and life-saving, basically saying they do it again. Members of the jury, make sure they can't. Make sure they financially can't make decisions like that. They've got to make better decisions or they will be done. Those are the kinds of arguments you can hear in the punitive damages argument. My Miracle Mama. Hi, Peter. God bless you. I was wondering what happens to the money awarded if appealed. How does that work for the families to not get the money get kept back? Yeah, unfortunately, they don't get the money if there is an appeal. They do not get the money. But eventually they could, and actually the defense has to pay more if there is an appeal sometimes. There are different factors that can make it worse, but it sucks. Belinda, I'm crying right now. This trial was so emotional. Absolutely. Jenny Nicole, career prosecutor here. Watching the difference in the standard of proof between civil and criminal action is wild. I told you, lawyers and the burdens of proof, we obsess over it. Obsess over it. Thank you, Jenny.
This is a comment on the pending litigation. This is, first of all, we've never seen this before. It's never been provided before. It's a complete ambush.
Your client apparently did it. I mean,
I understand that, Judge, but
He's like, Judge, this has never been provided to us. We didn't know about this statement made by Johns Hopkins. It's like you're saying, because when we talk as lawyers, it's very important to understand how you understand how this works. Lawyers are the mouthpiece of the client. So for me to stand in court and be like, Judge, we didn't know about this and we never saw this. I'm speaking for my client. So right now he's basically saying the people that made that video didn't know about that video. It's not how it works. We're being ambushed, something that made during pending litigation. It's like, yeah, I agree they shouldn't have made it. What's wild to me is, so I have some friends that run companies and I have some clients that run companies, and sometimes they'll call me from time to time and say, what do you think about this? Should I do this? I'm not their general counsel. Sometimes I'll help them out. If we do have a relationship, an attorney-client relationship, it'll be, more in-depth analysis and advice. How did they not ask Howard Hunter this question? Sir, we pay you a lot of money. What do you think about us making this video? I have to believe he would have been like, absolutely not. Do not make this video. That's what I would have said. I don't care how you feel right now. You just got to suck it up, bite your tongue. Let's see what happens, and we will deal with the aftermath. I hope they let this video in because that's the truth. That's actually how they feel and what they think. So why not let the jury see it? They knew people were going to see this video. I think Anderson was a little surprised when Howard Hunter said, we didn't know about this was an ambush.
litigation. This is, first of all, we've never seen this before. It's never been provided before. It's a complete ambush.
Your client apparently did it. I mean,
I understand that, Judge, but sitting here, this is a comment on the defense of the case that is essentially trying to punish the defense for trying the case and defending the case. It's trying to make the defense look bad for defending the case and taking a position with respect to what they've done. They're commenting on what's going on in court, but it's taken completely out of context and it should not be admitted at this point.
any response?
Yes, Your Honor, it's a party admission by the current president of Johns Hopkins All-Children's Hospital as to exactly what Mr. Anderson argued in his closing statement, which is they still don't get it. They still maintain their actions are heroic and life-saving. And the jury needs to see this at a punitive damages stage.
They still don't get
The
it.
court is going to exclude 2830. It is not something that occurred contemporaneously, and this is not something that the jury should see.
Come
What's
on,
next?
Judge. Come on, Judge.
Next, Your Honor, is what is there is 2832. We have several clips from town hall meetings conducted contemporaneous with the immediate jeopardy finding. Discussing this
Let's
case.
put that up. How long is this one?
I'll have to rely on Mr. Reyes.
1 minute 14, I think. No?
First clip is 37 seconds for the first one.
So let's talk about the survey results. So we did have the 12 surveyors, as you all know, on site. You all, for those who were here, had the opportunity to experience that. There's a couple things I want you to understand. Is when they were here, you may have heard me say this before, they were surveying us on a federal level, which is around the conditions of participation for CMS, and they were also surveying us at a state level. So this was both a survey for federal regs and also state regs. So let's first of all talk about what immediate jeopardy means, because that's the word that I think has gotten everybody's attention. And just so you all know, this is not my first time to be in an organization where there has been an immediate.
Judge,
So that's 2832.
Yeah, we'll call that 2832.
Is there another clip that's following?
There's several.
Let's do them all, and then we can have a discussion. What's the next number on?
We will call this 2832 Bravo.
I'm sorry, we'll keep going. Can you identify where on the exhibit list these were?
Are these things that were
Unfortunately, it
produced
didn't,
last
Kim.
week?
This wasn't. He came into a deposition with this. This was, as far as I know, this has never been produced. It's never been on the exhibit list. It was played during the deposition of one of our witnesses. We still don't know the source of it.
It's exactly like the homecoming photos of Maya Kowalski that were sent to them by an anonymous source, allegedly. This was provided to us by an anonymous source last week, just before the deposition.
Ooh.
Okay, let's play the next one. 2832.
By the way, public trials, streamed trials, hundreds of thousands of people watching this. You'd be surprised how people want to help a good cause that they believe in.
B as in Bravo.
The jeopardy that you can receive is something that's called around culpability. And that really is around the issue that leadership knew that there were quality and safety issues and did not elevate it in appropriate ways to the board. And so because of that, there were enough what's called conditions of participations noted that they felt it was important to give us immediate jeopardy. So I wanted you all to understand that the immediate jeopardy really is about system process issues of the way that quality and safety issues are driven to the board so that the board can govern and act like a board on behalf of All Children's Hospital.
Not just the Heart Institute, not just bad results, but systems and quality control and safety and reporting.
I'll also point out, I'm sorry.
Go ahead.
I'll just point out that Ms. Green testified that she recognized the media site, and the source of this is Johns Hopkins All Children's Hospital or the health system's internal media system.
What's the next clip, please?
Next would be Charlie, and Charlie would be 46 seconds.
This is
It's
an audio.
It should be. No, I'm still on 2832. Okay. Let's go to 5006 is the next town hall. 5006.
Okay, so what number are we
We're
playing?
still, I'm sorry, Your Honor. We're still going to be 10 seconds.
Was about information flow, data collection, how you really look at quality and safety, and how that gets fed back up to the board. So that is what immediate jeopardy means. Those.
And one more, Your Honor, 5007, Dan, which we will call, for purposes of the court, 2832 Delta.
It's a cultural issue. I think that's what the one thing that has struck me the most is that while on site, the stories that I've heard and the fear of retaliation and retribution, if you speak up and speak out, and people have real stories that they share with me, and I have that.
Okay, Mr. Hunter.
Three things, Judge. First of all, it was referenced during Ms. Green's deposition, and I'll reference it here. That voice that you're hearing is sped up. It's not his true speaking voice, and it's not particularly complimentary to him. Number two, if they're going to play this, if you're going to let this
If only Howard Hunter knew it's even more sped up here on this channel, which we're going to bump it back up to 1.5 because that did sound even a little fast for me when they were speaking.
I want to see the whole thing, and we have never been provided that. Number three, number three, we have not previously been provided this, and we'd like to at least have the opportunity to look at the whole thing because clips are being cut out of this thing out of context, and we don't know what the whole thing is. Okay, there are segments in this thing that were played the other night and that we have discussed internally that in which Mr. Sowers confronted some people and actually apologized for some of the conditions leading up to the immediate jeopardy. But finally,
You know who he didn't apologize to on the video we just saw while the jury was out deliberating? Maya and her family. He did the opposite of apologize. He said it was exceptional life-saving work that they did. And the jury thought it was so exceptional that they were making him pay $200+ million to this family because of what they did to them. Interesting.
the immediate jeopardy is, with all due respect to Your Honor and prior rulings, that is irrelevant to this case. Well, Your Honor's laughing. But
I'm saying because I just listened to the clips and there was nothing about the Heart Institute, which is what you were telling me in open court. All of this was about.
Ooh. Ooh. you. It's like, at this point, Mr. Hunter, I'm not sure I can believe you. And he gave him one of these. It's almost got Hunter Carroll doing the chop over there at Howard Hunter. Let's take another listen to that. He's like, Judge, this is completely irrelevant. It's like, well, yeah, I made all of those rulings calling the immediate jeopardy irrelevant to this case because you told me it had to do with the Heart Institute. And you know what the Heart Institute is irrelevant to? This case. But quality control, safety, reporting, and retaliation, those are literally at the heart, no pun intended, of this case. Wow.
Immediate jeopardy. But finally, the immediate jeopardy is, with all due respect to Your Honor and prior rulings, that is irrelevant to this case. Well, Your Honor's laughing. But
I'm saying because I just listened to the clips and there was nothing about the Heart Institute, which is what you were telling me in open court. All of this was about.
Well, Your Honor, and
I'm just saying, Mr. Hunter, it seems what you're saying and what I'm hearing do not match.
And what I was also saying, Your Honor, was that you're only hearing seconds-long clips. You're not hearing the whole thing. You're not hearing the entire matter. And it doesn't sound like you're prepared to listen to the whole matter.
Whoa, time out, because that's a very serious statement you just made. Do you really think I am not making balls and strike calls? I've just eliminated a couple of items from their exhibits, and I'm listening to your statement. So I just want to make sure, are you saying that I am closed-minded in this case?
Judge, I'm suggesting that.
Ooh, no. Don't say it. Don't say it, Howard. Don't bet it all right here. You've made your arguments. You've done a good job for your client. You fought hard and zealously, whether people agree with you or not. Don't call the judge biased at this point. First off, he's not. He just kicked that other video out that I would have absolutely let in. This is wild. This is wild.
On this particular issue, you have indicated a predilection regarding the Heart Institute issue that I don't think that I'm able to get past, and that's my problem with it. And on these particular clips, what you're also seeing once again, and I hate to sound like a broken record, but you just listened. This is a town hall meeting that went on for some period of time. I don't know how long it was. They've got a whole clip of it. Okay, a whole clip of it that I haven't seen, and frankly don't to this moment know the entire source of. But you're reacting and visibly reacting to clips from that thing that are seconds long. You're not hearing the whole story. And that's my problem with it, Judge.
Mr. Whitney, do you have...
But the point was, you said the whole thing had to do with the Heart Institute. And all I need is clips to tell me that's not true. Anne Marie, can the defense appeal on the basis that juror number 1 was not being shifted? He clearly had a conviction in his voice when confirming the verdict. I do think juror number 1 is going to be part of their appellate issues, but I don't think that's going to be successful. Here for years. Peter, you're doing a fantastic job. Keep it up. By the way, love your hair. Thank you. It's even better than Rob's. He's got a better beard, though. Better beard. Bodie, can the plaintiff offer a settlement now for a lesser amount and not appeal it? Absolutely. Absolutely. Margaret Ann, thank you so much for gifting more memberships.
Have the full clip?
So, Your Honor, we have portions of the town hall meetings. They were sent to us in discrete files. There are approximately 9 or 10 of them.
Discrete.
It's a notice. Ms. Green testified she recognized the media system these were being played from on Friday evening. And we had a busy weekend through no fault of our own. But at that point, Mr. Hunter's colleagues could have gone to Ms. Green and Kevin Sowers and figured out where this resided in the Johns Hopkins system. It resided with them, not with us. So they had, what day is it? Thursday?
So it's like somebody that works at Johns Hopkins is sharing this stuff with the plaintiff. And again, there's a lot of doctors and nurses in the chat saying like, yeah, we are good doctors and nurses. This is way worse than just a mistake here or somebody that wasn't nice or had a bad day. This is much worse than that. Doctors and nurses get a bad name because of situations like this. So they don't want to be lumped in with some bad apples.
Nearly a week to watch their own video. And the second thing I'll point out is that it's no different than Jack Kowalski having to sit here and listen to clips of Stephanie Graham's interview because we can't admit his, but we have to accept them as party admissions, and they should be forced to do the same of clips.
Have you turned over any other clips that you have not played here that they can see? Did you get anything else?
Yes, Your Honor, there's more to this, but they've never asked us to produce these clips.
Well, if the defense wants to see those additional clips, that's fine, and they should be able to see them.
I would add this, we tried to find.
I agree, American Mama Bear. I absolutely agree. So now that's not a good answer that they've never asked for them. There's continuing discovery rules in Florida, but this stuff is going fast and furious, and they're being provided this discreetly or anonymously. He should provide it to the defense. The judge should make them provide it to the defense. Netwoman, thank you so much. I'm super behind and crying. Yeah, I knew you would be once you got there. I mean, it's brutal to watch especially as they break down, as they hear individual yeses confirming validation that the jury believes them. This also is amazing. The fact that Jay Hatch had all of these high-priced lawyers, many lawyers, and Maya is a warrior fighting every day. I hope she continues fighting and knows that she unknowingly fought for all of us. I hope this makes sense. Can't see the keyboard through all the tears. It makes perfect sense, Netwoman.
This thing, and we couldn't. And I understand that Ms. Lawrence is related to a past or former employee of ours. I don't know what the source of that
That's
or
a false
not.
allegation. I mean, that's true that she is related to a former employee, but that was not the source of these, and that's a false
I
allegation.
just said I don't know.
Okay, well, I'm just clearing it up. Was it from that person?
Ooh, they called somebody specifically out. Miss Lawrence. I don't know who that is. I haven't been paying attention to the behind the scenes stuff.
The point is, there is a rule of completeness and context here that irrespective of whether I get the complete set of clips, which I appreciate, irrespective of whether I get those or not, these things are clips that got taken out of context and are being played as party admissions, even though the whole story and the whole statement isn't being played. And that's highly prejudicial, and it is also ambush, and it just shouldn't be taking place, Judge.
The court's going to receive into evidence 2832, 2832 B as in Bravo, 2832 C as in Charlie, and 2832 D as in Delta. What's next, Mr. Whitney?
And we have
I'm sorry, Judge. Am I to be provided the balance of these clips?
Yeah, didn't I just
we will
ask him to
send
do
it over
that?
immediately.
I didn't.
I apologize if I thought I had said that they need to see it.
And we're going to send them immediately.
Thank you.
So he's just making them send the clips they have, even though it's not the total amount. So the rule of completion, they can make some arguments about this, pulling it out of context, not fair. But either way, in context or not, they can play what they want. And then the defense should be able to play whatever other parts they want. They should be able to have access to this, but of course they can't get it. They can't get anything that's bad for them. And I don't mean anything to these lawyers or anything like that. I just mean generally, I get that feeling sometimes when I have these cases that they can't find their own security camera footage sometimes. Unless it's good for
The
them.
next is, Mr. Reyes, you have this as 5003 on your system. Your Honor, on the exhibit list here, it's 2758 Delta, and it is an audio clip of Ms. Beatty's sworn testimony.
And when did you first interact with Dr. Sally Smith?
Professionally?
Yes.
I've known Dr. Smith or known Dr. Smith for probably 15 years.
Okay, so you've known her for 15 years. Do you have a personal relationship with her?
No, just professionally, I see her here at the hospital and I've worked other abuse cases with her.
Okay. And approximately how many other abuse cases have you worked with her?
With her, probably here to the hospital, at least, I'm going to say 75 to 100. And in the last 15 years, probably close to 300 or 400.
She's an agent of the hospital, employee of the hospital. It's a sworn testimony. It's a statement against interest. It goes to, and they just checked yes on a parent agency. It goes to the pattern and practice of this institution.
Wow. It's wild stuff, Valerie. So I got to be careful about doing stuff live. I can't always control my facial expressions. Daphne, love that your Christmas tree is up. Love it. I'm a Christmas decorating junkie. I love Christmas. November 1st, my wife makes me get all of the Christmas decorations down from a huge storage space in our attic that I swear is just there for Christmas decorations.
And for the record, we have filed a memorandum. We were waiting to see what the jury did. We filed it at 227. It's a memorandum regarding the second stage of punitive damages and talks about the relevant, the determinations of relevance in the context of a stage 2 like we're at here.
Don't be fooled either, by the way. I know everybody's saying Johns Hopkins and all their lawyers. There's a lot of lawyers working on this case for Maya.
Mr. Hunter,
And
your
staff.
statement on
Judge,
exhibit 2758D as in Delta.
Judge A is from the dependency action. B, it's irrelevant. C, 227, a memo. I mean, I haven't seen it. And I doubt if the honor has.
I haven't seen it, but I understand the standard.
The jury checked the yes box with respect to Sally Smith. That issue's been settled. This issue is not relevant going forward on this, and this shouldn't be admitted.
Well, I agree. They checked yes on a parent agency with respect to medical malpractice. And so I don't see why the statements about, and clearly Sally Smith was wearing her hat as a medical director of the child protection team, presumably in these other cases. And so I don't see how that language is relevant for a punitive damage claim. So I'm going to exclude 2758D as in Delta. Anything else?
One more, Your Honor. It's 2831 on the list here, and this would be 5004 on your system, Dan.
Around, but they're different. It's the way they cut. Here you see the eye, here you don't. So if they do it this way versus this way, I mean, I'm not trying to argue with you. I'm just telling you what I see, and I understand what you're saying. I understand the position. The situation we're in right now is because they think we abuse our child and run away from us. I understand that. It's not. And we have to look through our innocence to try to get him back. I mean, so here, I'm not. anything that, you know, can take like A and B. No, and I understand. And I think all you can do is get different opinions. I mean, our radiologists have read it, you've had other people read it. Dr. Smith is our child protection person, Sally Smith. She's done that for years and years and years. She's the person who usually does all that. So. Yeah, she felt she's been for 5 minutes. But the problem is, to me, because there's so much controversy and nobody will probably agree on this because it's not cut and dried, and he didn't have retinal hemorrhages. He didn't have anything else. He didn't have, well, retinal hemorrhages are important because that's an important sign of shaking injury. So,
Wait. Is this talking about someone else?
Yeah.
Yes, sir.
No. Not coming in. 283.
I agree with him there.
Anything else?
Nothing else, sir.
And we can do the defense exhibits after they rest. Is that appropriate for the defense? Okay. Are we ready to bring in the jury? Mr. Anderson?
All right, so we're gonna jump up here to opening statements. Midwest, stupid question. Since she was awarded, not rewarded, the money, have to claim it on taxes. So you have to claim like wages, punitive damages, things like that on taxes. You don't have to claim pain and suffering damages on taxes. So a portion of it, yes, portion of it, no. Valerie, Peter, do you have privileges in any other state? I need you. We have lawyers that are barred or have reciprocity in like 30 states across the United States for wrongful death and personal injury claims. So reach out to me, lawyeryouknow@gmail.com. We're happy to help, pumped to help everybody that we possibly can from YouTube. I love when people call from YouTube. Azam is 47 minutes behind, but she is here now.
Publish or play or here of several witnesses in addition to Mr. Heath and Ms. Salisbury and Dr. Corcoran. And I'm trying to find out if somebody else is going to be published or played, or if there's going to be other witnesses beyond those people. This is the first time I've seen this. And this is like, I mean, they were told yesterday who we intended to call in the punitive damage phase. It indicated we were not told anything other than Mr. Heath. And this other stuff being brought up is classic damage.
Mr. Whitney or Mr. Anderson, I don't know who's handling that.
Yes, sir. We have Mr. Heath. We would like to call Saisha Mikado.
We object to Ms. Mikado. She's another person that is alleging misconduct during a child abuse investigation.
I'm not getting into other people's Chapter 37 proceedings. We're not doing that.
We would like to call Ms. Salisbury.
We would inquire what she's being called for.
Where is that? Well, one of the things she's been called for is to discuss that she has had the opportunity to take the deposition of Dr. Sally Smith. And in fact, that was at Johns Hopkins All Children's Hospital, where Sally Smith was wearing a Johns Hopkins All Children's Hospital lab coat during the deposition.
Why do we need that? That's already been found by the jury.
She also, we have an internal report by the way. She's also would testify as to the pattern practice of Johns Hopkins All Children's Hospital, calling in Sally Smith, head of any investigation, and the long-term damage that's done to families by this practice of Johns Hopkins All Children's Hospital. Sally Smith.
We object. The chilling effect already on mandatory reporting is shocking. We object to any more coming forward on behalf of abusing neglected children.
Under the law, the hospital has immunity for calling the hotline. We're not going to parade a whole bunch of people in and talking about other people's calling of the hotline and what happened because of those calls to the hotline. That's just not going to happen. So you can keep saying these people are going to be called, but I'm not allowing it. So
may I make one further point?
You may.
Except that the testimony will be it was the result of a hotline call. It was the result of the same practice here, which is involving Sally Smith as a hospital pediatrician ahead of any hotline call, ahead of any Chapter 39 involvement.
I'd like to just make a quick record on this.
I'm saying no.
I understand, but
okay, go ahead.
This is a problem that's infected this.
It's like, dude, you've already won. You've already won.
Respectfully, I know you're on trying to keep this up, but they've made their entire case about the involvement of Sally Smith to try to destroy the lines between what was immunity and what's not. And their whole argument about the apparent agency of Sally Smith was not for the medical care she performed at the hospital, but her role as a child abuse captain. We'd asked for this to be excluded, but we also noted that they're continuing to try to infect this jury with Chapter 39 issues. It should have been and have been excluded. We object to these witnesses.
Well, I think I've already declined to allow that witness to be called. What's next?
Our case has been greatly simplified. I think our
Here we go.
witness will be Steve Heath.
Okay, so there's.
Can we have I know you want to bring that immediately, Judge. Even if just you can sound that just 2 minutes because it really cuts down on a lot of our case. I just wanted to reorganize notes for 1-2 minutes.
I will tell everybody I will be back in at 3:10. Tell the jury they need to use the restroom, but we're going to start at 3:10. Okay, I'll be back at 3:10.
All rise. Court recess.
Move into the punitive damages phase. We're going to have opening statements from.
We're almost caught up.
Defense. Pamps?
I agree, Belinda.
And we'll see. Thank you for the past 9 weeks. We've just got a little bit more to go. So this is where we determine the amount of money necessary to change corporate behavior and make sure this kind of stuff never happens again. And our
Change corporate behavior and make sure none of this stuff ever happens again.
case is based around are the series of emails and memos you saw coming down from the highest up to the general counsel over to risk management and then directly down to Beatty and the folks kind of on the ground level, I guess, of the interaction with Maya that brought that verdict from you. So what we want to do here now is have you focus, and we can we'll bring them up as necessary. That series of memos when you're back there, you probably already remember them, when there were directions to do these things from the highest level of the company. And that's what we're talking about when you get a question on here about specific intent. It's not just like a general screw up of the company. It's about whether the company management, for its own reasons, decided on a course of action that they had to know. And in fact, in addressing it, address the fact it was going to harm this little girl. And this is somebody who is vulnerable by herself. She cannot get out of the way. She cannot escape. So it's about protecting the most vulnerable people in that hospital, in our society. So that's why we have punitive damages in this country. It is to force a change in corporate conduct. It is to overcome the inertia of we've been doing it this way for a long
Sounds a lot like an argument, but in punitive phase, they let you go a little.
time. And, oh, well, we got hit for a malpractice award. Let's put it over here on this part of the balance sheet. And if we're lucky, maybe the president won't hear about it. You need to make an award to make sure there's absolutely no question. Everyone in that organization, all the way up to the top, hears about it. And we're going to bring here, I think Nick's going to take him, Stephen Heese, who's the president of Chris Craft Boats. They're right over here off 15th Street next to the airport, the nation's oldest boat manufacturer, been around for 160 years. And Steve's not that old, but he's going to come in and explain to you a little bit about managing risk and why these kind of verdicts are important. Number one. Number two, fantastically, he's also a certified public accountant and was a partner at PricewaterhouseCoopers. So he knows how to run these numbers. So what we did was.
So we're going to hear a lot about numbers. Thank you, Patty, so much. I really appreciate it. You guys are being too nice. Stella by the Sea, thank you so much as well for the kind words. I mean, I get that you guys, say I'm creating it, but it's you guys that are the ones that make it such a fun chat, interesting chat, educational chat, and respectful chat.
We had them produce their tax returns and their financial statements, their audited financial statements. So we know how much money they were making, and we had Steve calculate their real net worth based on the furniture, fixtures, equipment, income, the $555 million in gross income they made 1 year. He's going to list all those out for you. Please take notes on specific numbers as they come in. And what we want to do here is assign a certain percentage out of net worth, out of revenue, or both, and that is within your province. But to effectuate what you check, yes, you believe punitive damages are warranted, it must be enough money to absolutely make sure that the highest levels of a very, very large company hear about this and are forced to make the changes necessary to ensure that this never happens to another family.
I actually think this is the best Anderson has done arguing the entire case. He understands this fully. He's driving the point home. Listen, if a guy's got $5 and you take $3, that's punitive. He's going to remember that. He's just lost more than half of the money he has. But if a company's worth $500 million, you pick the number. What's going to make them feel it? $10 million ain't going to do it. So we're going to see all those numbers through this phase. This is going to be awesome. This is going to be really cool. This is very unusual. I don't know that I have never handled a bifurcated punitive damage trial. I've made these punitive damage arguments before. We've gotten punitive damages on cases, but we've never been in a situation where I've done a bifurcated trial like this and been able to do a very specific punitive damage argument. So this is going to be awesome. I'm excited about this.
That's the mission, right? So you'll get a verdict form, and it'll have several questions. This one, thank goodness, is only 9 pages long, so you won't have to spend reading another novel after writing a novel on each witness. And you'll go through it, and it'll have questions that ask you, based on Mr. Heese's testimony, on the various incidents that we're talking about. I don't know. It just is so insulting to call these things incidents. The damage, the injury to Maya and her family at different, same ones you saw before and checked yes to. And there are 2 types of questions. One,
a different kind of confidence, right? You know this jury is with you. You know this jury believes you. You know this jury trusts you. I don't know who's going to do it for the defense, but it's tough when this jury just kicked you in the gut, and now you got to go make more arguments and ask them to do stuff that they don't want to do with anything you say.
One is on clear and convincing evidence, how much per incident, just like you did before. And the second one is, and importantly, about
Exactly
specific
like you did
intent. And
before.
that is where you signal whether you understood and agreed that from that highest point there, they had made up their mind to initiate a policy that led to what you saw for 9 weeks. And so you can have any evidence you want. It's all back there. You can go back and check those emails. I made a big deal about them in my opening 9 weeks ago. If you need those, check them out to confirm what we're saying is correct. But you'll see there that risk management had directed this stuff. And that's why it's so important to get into that specific intent. Because again, this is all about sending a message. The first part of your case was about compensation. Now that's over. Now what we're doing is correcting behavior, right? We're correcting behavior. And again, I keep saying these things because you all have been around this planet long enough to know how companies act, how people act. And you know that to get people to change and to get companies to change takes a lot. And so that's why these numbers are going to be big, as big or bigger than what you've already awarded. But they're based on a different scale, and they're based on how much a company is worth. It's $1 billion company plus, and how much it makes per year. And these are the only ways that our country has come up to find a way to change corporate behavior. So at the end of it, I'll have a chance again to talk to you about it. I'm keeping this short. You've done a fantastic job so far. We only need you a little bit more to do the right thing here on behalf of now you're talking not only for the Kowalskis, but for everyone. Okay? That's all I got to say right now.
For everyone that could step foot in that hospital again, make sure they don't do this. CM Mosier, would the plaintiffs be able to appeal if they lost? Yes. Yes, they could. Rebel Duck, when I worked for SSM Health, they actually use real malpractice cases as a teaching tool for newcomers. I appreciated that hospital even more for not hiding facts. This is a turning point for J Hatch. I really hope so. And I believe it could be. I really do believe it could be. I don't think this is going to bankrupt them. I think they're going to be able to make whatever the settlement amount is. I think they're going to be able to pay it. And I really hope that this is real change. Maggie May, this case really helped me understand the incalculable value of plaintiffs' attorneys like Peter. I really appreciate that, Maggie. And I agree with you. It's really important, but it's the client's case, right? It's the client's case. If a client's lying or exaggerating, I don't care how good the lawyer is, you don't deserve this kind of money. But if you've got a real case like this that a good lawyer believes in, go hit a home run.
Mr. Sheriff. Good afternoon. No surprise, obviously, my team's very disappointed by the verdict. But I do have a chance to talk to you one last time about what they're asking you to do.
No surprise, my team is very disappointed by the verdict. I don't think I would have said that. I think I would have just been like, we get it. You guys think that what happened to Maya Kowalski is Johns Hopkins All Children's Hospital's fault. And what you've done is already going to cause a change. That's probably what I would have gone with. The $200 million you've awarded is a huge number, and we get it. We understand. My client understands what you felt, what you saw, what you thought, and that's going to cause a change. These punitive damages are totally unnecessary. That's probably what I would go with.
I represent a nonprofit organization. It's a children's hospital. You're going to hear testimony that every dollar that is awarded in this phase is a dollar that we don't have to spend on medical care in this community. We're going to learn a couple things.
It's a good argument.
And it's simply this. The Kowalski Seeger verdict have been, so the punitive damages, so you know, are only for, I think you sent the verdict form, and I know you spent a lot of time with it. They're for the false imprisonment and the batteries, right? They're not for medical care. By my math, you've now awarded $57 million.
They're not for the medical care or the wrongful death claim that you found Johns Hopkins caused, right? He's leaving some stuff out there, but he's right. 57 million, I think, is what I said too. So the 3X cap would be, you know, whatever we said, 171 million or something.
To the Kowalskis for the photographs in the false imprisonment, and total compensation for the Kowalskis is approaching $250 million. I would suggest to you that's fair compensation.
There's the
more
argument.
than fair compensation. In terms of what they're asking you to, so these punitive damages are to punish and deter, right? So a couple things to keep in mind. Obviously, I don't have a chance to just sit down with you and find out what drove this specific anger. But if it was Kathy Beatty, she no longer works at the hospital. So that's not something that you have to keep in mind that we need to punish or deter.
So I don't know what caused the anger, he said. So he agrees they're angry. He's right. They're not angry at him. They're not generally angry. The hospital's actions made them angry. So now he's going to try to mitigate some of that anger. It feels like a bit of a sentencing phase, right? And he's talking to the judge to mitigate how bad to punish his client, how long to throw them in jail, you know, metaphorical jail, financial jail, maybe. Thank you, Azam, for gifting a membership, and Kelly. Yes, Tina, I'm learning with you. learning with you, different ways to make these arguments. I always learn a lot. Every time I watch a trial, even if it's something I've done 30 times, I still learn because it's different ways, different people handle things, different ways judges answer different lawyers. I love learning.
Or anything she did, if you found that there was something that she did that was improper, I would suggest to you that's not something that you need to send a message on. I also remind you, in terms of if this is corporate misconduct or something you heard from Mr. Corcoran that you thought All Children's was doing improperly, I would remind you Mr. Corcoran did say that after whatever surveys came down that he was concerned about that All Children's did an excellent job of correcting them, and now there is an open culture of communication that can.
By the way, if you're wondering why they can talk about this stuff if it's not going to be evidence presented in the punitive damages phase, because usually opening statements are limited to what evidence you expect to be presented during that trial, and this is phase 2, and we only heard one person for the plaintiffs can testify about numbers and things like that. You can also talk about the evidence that already happened in phase 1 that applies to the phase 2 part of the trial. So that's why they're talking about some of that evidence, just a little, to make sure you guys understand what's going on there. Netwoman just continues to be overly generous and welcoming 10 new members in.
Reach the highest levels, so we wouldn't need to see any type of message coming from this jury to correct any future conduct, because all of that's been corrected. But again, we would suggest to you that on the false imprisonment, just keep this in mind, and I don't want to re-argue the evidence because obviously you disagreed with me. But in terms of punishing, deterring, I thought I did what I could to let you know that the reason why All Children's back in that first week where you've awarded a lot of money for what they call the false imprisonment, just that 1 week before the abuse hotline led to the shelter, that All Children's did that.
What they call the false imprisonment, okay, I'm sorry I'm being nitpicky here, but you've lost now. So we've got to relax. They, meaning the plaintiffs, were not the only ones that called it false imprisonment. Also, they, the 6 of them in front of you, called it a false imprisonment. So at this point, legally, it was a false imprisonment.
Because they were concerned for Maya. And I do fear that a verdict on punitive damages to punish and deter healthcare providers for speaking up when they see children that they think are susceptible to leaving and being put into a ketamine coma that they believe is dangerous, to being taken and put in intrathecal clonidine pumps that they think could lead to patient death, that sending a message for punitive damage is really going to create a silencing effect at my hospital, where it's going to chill people from ever speaking up again.
So we're worried about chilling people from speaking up again when, after your audit, they literally said you guys retaliate against people that speak up against people in your hospital.
You know, we won't take too much more of your time, but I would just humbly suggest that since we are talking about policy, that there's been $250 million awarded to the Kowalskis, and punishing and deterring and trying to silence healthcare providers when they have a genuine concern is going to be tragic. I look forward to talking again once we're done this process. Thank you.
Parts of that were tough to hear, but parts of it I think were good arguments. As good as you can do, you got to realize the position he's in, right? Got to realize the position he's in. June, I noticed during the trial, the flag polls, is it normal for the eagle to be on the state flag instead of the eagle on the American flag? I have no idea. Sorry, not my expertise. Netwoman, you were right, Peter, when you said yet for me to question. When they said that this was systemic, does that mean it's isolated to the hospital in Florida or all JHATCH in all states? I think just Florida. That's all I've heard. That's all I'm willing to say. I don't know about any of the other Johns Hopkins. I mean, they have all great reputations. I remember when it first came here, my parents were so excited, but it hasn't gone well for them. Okie, Texas girl. Big money, big money, big money. Just like when they spin the wheel on Wheel of Fortune, deep pockets require deep punitive damages to make an impact. And this is exactly the arguments the plaintiff's lawyers are making. Charles, what would be your strategy if you were on the defense team to mitigate the award in this phase? I think he made a good argument saying they're nonprofit, good argument saying we don't want to silence people calling out child abuse, and a good argument saying we're already paying $250 million. Or whatever it was, 200 something million dollars. So those were 3 of the arguments I would have made. I would not have tried to validate any of our conduct. I wouldn't have said they call it false imprisonment. Just admit defeat at that point and try to get them to have mercy on you. Basically is all I would have done, Charles. How you doing, Charles?
May I call your first witness? We'd like to begin, Your Honor, if we could, by publishing several exhibits of videos.
May. So let me start evidence.
There we are. We will begin by publishing 2832 Alpha, previously admitted.
The opportunity to experience that.
Hospital.
Oh, so they let them put these video clips in.
So let's talk about the survey results. So we did have the 12 surveyors, as you all know, on site. You all, for those who were here, had the opportunity to experience that. There's a couple things I want you to understand. Is when they were here, you may have heard me say this before, they were surveying us on a federal level, which is around the conditions of participation for CMS, and they were also surveying us at a state level. So this was both a survey for federal regs and also state regs. So let's first of all talk about what immediate jeopardy means, because that's the word that I think has gotten everybody's attention. And just so you all know, this is not my first time to be in an organization where there has been an immediate.
That video excerpt. We'd next like to play 2832 Bravo, previously admitted further from the town hall meeting.
Jeopardy that you can receive is something that's called around culpability. And that really is around the issue that leadership knew that there were quality and safety issues and did not elevate it in appropriate ways to the board. And so because of that, there were enough what's called conditions of participation noted that they felt it was important to give us an immediate jeopardy. So I wanted you all to understand that the immediate jeopardy really is about system process issues of the way that quality and safety issues.
I literally thought the same thing, Carol. Like a weight has been lifted in this misery.
Are driven to the board so that the board can govern and act like a board on behalf of All Children's Hospital.
2832 Charlie, another clip from the town hall meeting.
Was about information flow, data collection, how you really look at quality and safety, and how that gets fed back up to the board. So that is what immediate jeopardy means. Those.
And to conclude the video clips from the town hall meeting, 2832 Delta. If you could turn this up.
If Your Honor has the ability to increase it from the bench, that's as loud as I can get it.
That's as loud as I can do it. I don't know if we'll get any feedback, but there you go.
Is a cultural issue. I think that's what the one thing that has struck me the most is that while on site, the stories that I've heard and the fear of retaliation and retribution, if you speak up and speak out, and people have real stories that they share with me, and I have that.
Next, Your Honor, we would call Stephen Heese to the stand.
So best self, that's only if they are limited by the cap, which is 3 times compensatory damages. If they answer yes to the question, which I think they will, it could be unlimited, no cap.
Stephen Heese.
And would you please introduce yourself to the jury by way of your current position and profession?
Sure. I'm the president of the Chris-Craft Boat Company in Sarasota, Florida. It's America's oldest boat builder, been in business for 150 years.
Thank you, Mr. Heese. I'd like to discuss for a few minutes your background, training, and experience. The jury knows the drill by now, but would you please give us the benefit of your formal education in business?
Formal education. I have an undergraduate degree. I grew up in Tampa. Went to Jesuit High School. Went to Tulane University in New Orleans. Got a degree in accounting. Worked for several years at Pricewaterhouse. Went to business school at Harvard University in Boston. And that's the limit of my education.
Sure. Did I understand? It was a master's of business administration MBA from Harvard Business School?
Yes, with a concentration in finance.
Understood. And that was very brief. I'm going to explore it a little bit more. You mentioned, if I heard you correctly, that you worked at PricewaterhouseCoopers between undergrad and business school. Is that correct?
That's correct.
What was your role and function at PricewaterhouseCoopers?
Started off in the audit department, and then after healthcare.
Large hospital systems, is that correct?
Yes. I also grew up in a medical family. My mom was a midwife. My sister's a nurse. I have aunts and uncles that are nurses and doctors. My daughter is a pediatric ICU nurse at Children's Hospital in New York City.
And we don't need that. What took you from Harvard Business School to president of Chris-Craft?
I have, since business school, I've made my living buying broken companies, fixing them, and selling them, particularly in the power sports business.
And so, am I correct in understanding that Chris-Craft, when you purchased it, perhaps was somewhat broken?
It was at a bankruptcy auction, completely shut down in 2000. It had gone bankrupt.
And you've been president of Chris-Craft for how long now?
23 years.
And under your management, has Chris-Craft been successful?
Yes.
How many employees do you have at Chris-Craft?
About 400.
And through your management of Chris-Craft, have you had to purchase and manage the healthcare benefits and systems of Chris-Craft?
Every year.
If you could, let me ask you an opening question. Is risk management a concept that you learned at Harvard Business School?
Objection, relevance condition.
You can answer. Risk management, concept of risk management. Would you please explain what that means, whether you're talking about the healthcare industry or you're talking about the marine products industry?
Sure. In any business, there's risk. Risk is something that every business has to manage. Many risks cannot be eliminated. In the marine industry specifically, boats have propellers, they've got fuel tanks, they've got carbon monoxide, they're used in the water. People are having fun when they're using them, often eating and drinking. These are genuine risks that a manufacturer has to understand and manage and do their utmost to mitigate.
What role does culture
play within an entity, whether it's Tampa General Hospital or Chris-Craft, in terms of the risk management attitude of the employees and leadership?
Objection again, innovation.
Overall.
Could you ask the question again?
Sure. What role does culture play in terms of whether you're looking at an entity like Tampa General Hospital or Chris-Craft as culture interacts with risk management?
Again, foundation speculation.
It plays an important role, but not the only role. But for sure, the attitude of the employees is reflecting on the attitude of management and management's approach to managing the risk. So, if management is seen to be insisting that people are certified, insisting, with the standards that govern their activities, and if there's procedures in place to deal with exceptions, employees know that the employer is seeking to do the right thing at all times, top to bottom, and that culture gets created where those risks can be managed and mitigated.
Having taken over Chris-Craft when it was in the midst of bankruptcy, did you have a challenge in creating the proper culture within Chris-Craft to take it from bankruptcy to success?
I've been committed to standards and training of employees. And so those are the foundations, the systems, training, ideally outside certifications and training, written procedures that are followed and reviewed. These are the fundamental building blocks of risk management.
Throughout your career, whether it was at the beginning of PricewaterhouseCoopers or in your past 20-something years with Chris-Craft, have you seen instances where the culture was such that it allowed retaliation and retribution for employees that spoke up about doing the right thing?
Objection, foundation.
Overall.
I have certainly seen that.
And how important is it to stamp out that type of culture that would allow such actions by leadership?
If the company is going to sustain itself, it's really important, critically important.
All right. Now, I'd like to discuss with you your report, which I believe you might have a copy there. And let's just keep it there for now. You'll have it as a reference. If you need to refresh your recollection, let me know. But for now, let's just try to do this from memory in general. Okay. Have you had an opportunity, well, as part of your presidency of Chris-Craft? Our job keeps getting easier. So, if we could publish or deliberate Jay or Juliet, which is the next year's tax return. But let me start here because, first of all, would you explain to me and the jury what we're looking at here?
The first page is irrelevant.
What document is this?
Oh, it's a tax return for the 12 months ended June 30th, 2021. And it gets filed on the previous year because it's in the middle of the year. The new tax form isn't done, so they use the tax form for the previous tax year.
And informing your opinions, is this the document that you relied upon?
Yes.
And so it says 2020 in the top right corner.
Yes.
If I understood your testimony, you're telling this jury that Johns Hopkins Children's Hospital files their taxes mid-year, so they would file in mid-year 2021, even though this says 2020.
Correct. So if you look in the middle of the page at the top, it says for the calendar year 2020 or the fiscal year beginning July 1, 2020 and ending June 30, 2021. And so that the forms all follow that same time frame.
All right. Now, focusing there on page 1, would you please tell the jury what total revenue was for Johns Hopkins Children's Hospital in the fiscal year ending June 30th, 2021?
Yes, so you have to go to page 9. I don't know if you all have this in front of you.
We can get whatever page.
So total revenue, 555 million.
Page 9, and the pages are in the upper right-hand corner. Total revenue for that year was $555 million. And that's in the bottom of column
It's a lot
A,
of coin.
Bottom of page 9.
Re-express what you just said. So now
Start on page 9.
If you would direct us to the figure that you were just...
And it's highlighted in yellow. What sent out to its patients and other people that it provided services to.
All right. So you're aware that we're here to discuss a punitive damage award if the jury deemed that appropriate here. Direct me through the document as to what figures and categories you would look to in determining what resources are available to Johns Hopkins Children's Hospital to pay any punitive damages award that the jury deems appropriate.
So it starts on page 9, but if you go to page 11, it's the balance sheet of the entity. It's a nonprofit, which means that it seeks not to make a profit. Any extra cash that's left at the end of the year gets invested in the company the following year.
As of, please. And if you could scroll so we can see the page number at the top so the jury's oriented, they'll have that back there with us. We're at page 11.
Yep. So
cash, non-interest bearing.
So that's $62 million that they have in there. Cash, non-interest bearing, that's typically in a checking account. Checking accounts don't pay interest. So that's at the end, it's column B actually, 46 million at the end of the year. The $62 million number is the start of the year. Column B is the end of the year, the $46 million.
So the jury can understand that at the end of the fiscal year 2021, June 30th, Johns Hopkins Children's Hospital effectively had $46 million in its checking account.
That's on line 1, yes. But really to get a clear picture, you need to go down to line 11 and add the balance of line 11, which is $518 million, which is publicly traded securities. So those are stocks and bonds that you could decide today that you wanted cash, tell your broker to sell them, and you have cash tomorrow.
So that $518 million figure here it would not be difficult for Johns Hopkins All Children's Hospital to liquidate those publicly traded securities.
And write a check due date from now.
They're traded on public markets.
It says publicly traded securities. People don't usually lie in their tax return, so I would say yes, that is publicly traded securities that could be sold.
And if we do, I'll just focus on line 1 and line 11. If you're good at mental math, imagine you are. What are we talking about here for resources available to pay a punitive damages award?
$570 million roughly.
What other lines or figures would you look to on this one to determine if there's any other assets?
Right below there, you have almost $6 million in other securities, and then line 13, you got another $24 million in program-related investments. I don't know what those are, but there are certainly investments, and there's money sitting there.
By the way, were you available to attend?
Some pretty huge numbers at the bottom. If you look at total assets, there's a 1,000,000,000,000,000,000.
CFO of Johns Hopkins All Children's Hospital this afternoon at 1 o'clock.
I was available.
And given what's happened here today, you didn't have a chance to hear that testimony, did you?
No.
So you haven't had an opportunity to explore as we sit here at 3:45 what this program-related investments are?
No.
All right. So considering those, am I correct that if you were at $570 million more or less before, we added another $30 million, we're now roughly $600 million?
Correct.
Are there any other figures that you would look to on this form to determine what Johns Hopkins All Children's Hospital would have available to pay a punitive damages award?
If you go further down the balance sheet, there's fixed assets, property, plant, and equipment, and real estate. So if you,
And you took it down, we're looking at a different page now.
let's have a look.
Sure.
I'm sorry, line 10A.
On the same page?
10A and 10B.
All right.
So there's 394 million roughly in property, plant, and equipment. And that number is purchase price less depreciation. So it's what was paid for originally, less depreciation each year that goes by. Land doesn't get depreciated. So it was bought a long time ago. So I'm guessing it's substantially undervalued compared to these numbers.
And if I'm correct, the depreciation there is a tax concept, right?
Correct.
But if the purchase price here was, it looks to be $650 million for the real estate.
Land buildings and equipment.
$650 million.
Correct.
And so the figure there in the right column, $394 million, is after depreciation, but that doesn't reflect the true depreciation value. That reflects how it's held on the books after depreciation is accounted for.
Correct.
So you made a statement that the 650 million, the 394 significantly underestimates the real estate assets available to Johns Hopkins All Children's Hospital, right?
Typically, yes.
And is it your opinion that if the purchase price was $652 million, that Johns Hopkins All Children's Hospital would have real estate assets in excess of that amount given inflation, depreciation, et cetera?
Yes. Calls for speculation.
And again,
I think everyone knows what's happened to Florida real estate over the last 10, 20, 30 years.
Sure. You say from Tampa?
Yes.
How long has All Children's Hospital, if you know, been in that location, in those buildings on that campus?
Since I was a child.
Does that support your opinion that these numbers here are significantly undervaluing what the worth of those real estate assets is?
Yes.
Interesting.
Okay. But we can go with the
So it's like, oh, there's even more value than it looks like.
we have here. So before,
It's true,
we were at
but-
$600 million in cash and cash equivalents. Am I correct?
Yes.
And here, although significantly underestimated, we have another $400 million.
Although significantly underestimated.
As it's on the books.
Land building equipment, yes.
And so we're at approximately $1 billion now.
Yes.
The Johns Hopkins All Children's Hospital will have available to pay any punitive damages award.
Yes.
We have a moment. Thank you.
No victim impact statement in civil cases, just criminal cases. John, you dog. You dog.
I'm also guessing that the hospital has insurance typically.
Yikes. I almost skipped ahead. I'll back up just to make sure nobody missed that. I thought he was pouring water. No question is pending, and this expert just made a big mistake.
I'm also guessing that the hospital has insurance typically.
That's unbelievable.
Did he say that's unbelievable? Is that what the lawyer said? So in Florida, as much as it doesn't make logical sense because the insurance companies lobby and have so much money and get the legislature to do what they want to do so often, there is a statute called the non-joinder statute. And you are not actually allowed to say the words, this person has insurance, in the vast majority of cases. So when you're in a car accident and Miss Jones rear ends you, Miss Jones could have $250,000 worth of insurance, but we don't get to tell the jury that. We just tell the jury we want Miss Jones to pay. Miss Jones is going to have to pay. So they think, unless they already know, usually we're here because there's insurance, and most people know that there's insurance, that Miss Jones has insurance and the big bad insurance company is the one that's actually going to foot the bill. Well, in this case, I don't really think the jury cares whether or not Johns Hopkins has insurance. They just gave $210+ million as a verdict, but you still cannot say that. And that often is reason for mistrial. And because it's bifurcated, potentially they would have to get a new jury to just do phase 2. I don't even know. Again, this is so different. I don't even know how they would handle it. The judge is going to have to cure this with an instruction to the jury. Members of the jury, strike that last statement that he said. I'm guessing the judge is going to have to say, disregard any mention of insurance. It cannot come into play in any decision-making that you have. It is not part of the evidence, blah, blah, blah. Some way to go over the top to try to fix this and cure this problem, because this is actually a pretty common way to cause a mistrial in a trial like this, in an injury trial, to talk about insurance. It's a big no-no in Florida. A lot of money and lobbying and fighting and litigation has gone on for them to get this big win. And in my opinion, make a totally unfair situation. Like, why can't they know there's insurance? But them's the rules. So we'll see. No, it's civil battery. People are asking if it's criminal battery, false imprisonment. It's civil statutes. This witness is like, oh crap. Somebody probably should have told him. So I will say, I always tell my witnesses, don't say insurance. And this guy is not your average witness for PI trials, right? Doctors that testify a lot in personal injury trials, experts that come in a lot and talk about life care plans, or Christy Kirby, she would never say insurance. This guy is more of a normal business CPA corporate guy that's going to discuss this stuff. So he's probably not used to testifying in trials like this. That's my only explanation as to why he would ever say the word insurance, because that is a huge no-no in Florida and many other states. Mr. Carroll's like, or Judge Carroll's like, what are we going to do here?
On that last comment you heard about.
Yep. Curative instruction. Curative instruction. What you got to do. And that's a big sigh of relief for the plaintiffs, but yet again, another appellate issue, and something that they're probably going to be able to devalue how much they offer because of.
Members of the jury, on that last comment you heard about insurance, the first thing you need to do is totally disregard it. The second thing, I'm going to tell you that under Florida law,
Insurance does not address or cover punitive damages. So there is no insurance for punitive damages. So you were to totally ignore the comment made about insurance coverage.
That's a great point. You know what else it doesn't cover? Insurance usually does not cover intentional conduct. And if they are going to find specific intent, that they specifically intended to harm Maya and did in fact harm Maya, insurance wouldn't cover that either. Insurance doesn't cover battery, doesn't cover false imprisonment usually. It usually covers negligence. We've talked about this a lot on the channel, and this is just a good reminder. We need a yikes skew of the merch. Love it.
Mr. Whitney, you may continue.
Are there any other figures on the balance sheet here that we haven't focused on that would inform your opinion as to the assets available to John?
Rain Man. Boom. You're right. Smart. Not just the best chat and most respectful chat, also the smartest chat in YouTube.
Hopkins Children's Hospital to pay a punitive damages award?
No.
Having reviewed the balance sheet here with the jury, page 11 of 2279 Hotel, have all of your opinions been based upon your background, training, and experience and offered to a reasonable degree of accounting and management probability?
Yes.
And ultimately, what is your opinion as to the resources or assets available to pay any punitive damages award in terms of the numbers we discussed on the sheet?
At least $1.2 billion.
When you say $1.2 billion.
Correct.
No further questions this time.
Mr. Shapiro.
So if you wanted to do, like John said, 10%, that's 120 million. If you want to do 50%, that's 600 million. So they could really get crazy with how bad they want to hurt Johns Hopkins and make sure they don't do this to anyone again. And if they answer the questions appropriately, there will be no cap on those punitive damages.
Mr. DC, you know Mr. Anderson for what, 20 years?
Yes.
You guys were hugging and high-fiving in the hallway, weren't you?
Ooh. You've known Mr. Anderson for years. You guys were hugging and high-fiving in the hallway, weren't you? Oh, boy. Personal friend here. Again, doesn't bother me. You guys let me know. What do you think? What do you think? Do you have a problem with that? If this guy was just out there hugging and high-fiving the plaintiff's lawyer saying congratulations, and then now he's coming and testifying for him? Let me know what you guys think, because you guys are much more in tune with jurors than I am.
What do you mean?
I saw you hugging and high-fiving Mr. Anderson in the hall.
I high-fived him.
All right. Let's talk a little bit about your opinions. This is a nonprofit charitable organization, true?
It filed a tax return on a nonprofit tax return, so I'm assuming it's a nonprofit.
Yeah, this is a children's hospital. That's my point. You know this is a nonprofit
Whoa.
501c3.
All right,
true?
so this is very combative right off the jump, and it's adversarial. And he probably did not like that comment about high-fiving and hugging Mr. Anderson. But now it's not going to be a nice exchange.
All the money, and I think you said this in fairness to you, all the money that's left over at the end of the year gets reinvested back into the community, true?
I don't know what the community, the entity.
Right. And do you know what the charitable mission of All Children's Hospital is?
I'm not aware of that.
It's right there on the tax return before you testified you didn't look.
You can draw my attention
Sure.
to that.
2279H002. We can put it up on the screen. See summary part 1?
Yep.
What does it say?
I was looking at part 3. Part 1, which page are you on?
Please briefly describe the organization's mission and most significant activities. Am I reading this right? Provide leadership in child health through treatment, education, advocacy, and research. Is that right?
Strive to provide the highest quality of care to improve the health of the entire community through innovation, collaboration, service excellence.
Well, let's talk about innovation. Are you aware that All Children's has a training program to train the next generation of doctors and residents?
No,
You've lived in the community for 20 years. You have no idea there's a residency training program?
did not know that.
Did you know that All Children's receives grants to do research?
Yes.
Okay. Let me ask you a little bit about, you talked about
Good
revenue
point.
of $555,256,053. There's expenses, aren't there?
Yes.
What were they?
If you look at the following page, the total is there. $519 million.
And that was with CARES Act money, true, right?
I don't know the answer to that.
Well, you can look the prior year, they actually spent more than they took in, true?
The prior is not on the page.
Let me ask you this. Whatever All Children's doesn't spend as a 501c3, you know they have to they reinvest it back in the company, right?
Oh, he just had a slip up there. They have to reinvest it back in the company. And that's true. But guess what? Some of the ways they reinvest it is the CEO gets a $10 million bonus, or, a lot of stuff like that happens. Like people that were involved in the positions that were involved in this case, they may no longer be there, but the positions they held got bonuses based off that money. I would ask that question on redirect. Like a lot of this goes into the board and the people, the higher ups that wanted this culture and pushed this culture of retaliation. And even some of the surgeons that were creating problems got bonuses off of the money and things like that. Talk about where that money goes. What does reinvesting it mean? It doesn't all go to the residency program.
Not necessarily. They've got an awful lot of cash on their balance sheet.
Well, let's talk about that. Are you aware of what their strategic plan is?
I'm not already privy to that.
Do you know what All Children's plans on doing with the cash in the balance sheet in terms of helping this community facilitate patient care? Do you know?
Given that the cash balance is fairly stable from year to year, I would say they invest it.
When you talk about property, you mean the property where the hospital sits, right?
The line is called property, plant, and equipment, so that would include the land that the hospital sits on, yes.
So if they sold the land where the hospital sits on, there's no more hospital.
Now you could do a sale and lease back.
Okay, and if they sold property that they may hold in Sarasota, Florida, where they're going to build a clinic to, for example, take care of children dying from cancer, to pay this award, that would hurt the community, wouldn't it?
Objection. Overruled. You ask the question again.
Yeah, if when you talk about selling property, this isn't beachfront property. If they're selling property in Sarasota County, where they're trying to build an outreach center to help treat children who have cancer so they don't have to make the drive to All Children's, that would be the type of property they would have to sell, right, Mr. Peace?
What I'm suggesting is they don't have to sell it to a third party who's going to put up a 7-Eleven. They could sell it and do a lease back, continue with their strategic plan, and pay rent if they needed to. But I'm also suggesting that I don't think they need to because they're sitting on an awful lot of cash.
That cash is needed because if you don't have an adequate balance sheet, you can't borrow money, can you?
So the point of cross-examination here is to act like they don't have any money. Nobody's making money hand over fist here. It's just a nonprofit. We're just helping the community these jurors live in. And if you take from the community, you're just hurting everybody. You're not really hurting any of the real bad guys. Kathy Beatty doesn't work here anymore. Thank you, Netwoman. Yeah, I'm glad you got some positive feels today because this was a good day for that. Rebel Duck, wouldn't JH have a high value bond? Probably. I don't know what the bond would be in this case, depending on how they appeal it, or what would happen with settlement discussions. It would not fall under insurance for the most part. Thanks for expanding, Peter. Love the lawyer, fam, as do I. Azam, dumb question, and maybe asked before, Peter. Why'd they have this punitive trial separate from what we have seen? Did I ask that correctly? Yes, you did. They bifurcated it, making two separate trials, because they didn't want to cross over this information with the first trial, and it would be unnecessary if they didn't win, so we wouldn't have to waste another day doing this stuff if they weren't going to win, but they did, so now we do it. Huge. Huge.
It depends on what assets you have. There's all different ways to borrow money.
There are credit rating agencies that look at the hospital's financial stability, and if they're not properly financed, they can't get money. True?
If the balance sheet is in poor condition of a company, it will have a hard time borrowing money.
Right, because if there's $200, $300, $400 million going out the door, that's going to have an adverse effect on the balance sheet of a company and their ability to continue to do business. True?
No, it depends on the cash balance that's there at the beginning and what gets paid out.
Well, let me ask you, you said operations include equipment. That would include ventilators keeping neonatal children alive. True? That's equipment.
It would include all the equipment.
Listen,
in the hospital.
a hospital, you can make a hospital seem like the most sympathetic defendant of all time. Except when this jury that's sitting over there just said this hospital falsely imprisoned, battered, was responsible for the death of this child's mother. They're not going to sit over there and think about, ventilators and cancer patients and the children that you're helping, because they're probably thinking, and that's why the plaintiff wanted to put some of this evidence on, how many other children did you hurt? How many other families did you ruin? That's probably what they're thinking at this point, knowing what they've already done as far as a verdict goes. Belinda, a hug is fine outside the courtroom. It's just an expert witness that's about to testify. That's kind of tough. That's kind of tough. Carol, thank you so much for gifting the membership.
That would include the MRI machine that can detect early brain cancer and potentially save lives. True?
Equipment typically goes down in value. Land and buildings go up in value.
Right, and that's why they have to do constant upgrades on equipment with the cash they have, so they don't have outdated technology. True?
Correct.
Do you sit on a board and decide when, well, let me ask you this. As president of a company, you have to decide where to allocate your dollars, right? Money's fungible. If you lose money in one area, you don't have it to spend somewhere else.
Correct.
And have you ever had to sit on the board of a children's hospital to decide whether to upgrade the MRI machines that are detecting cancer versus the ventilators that are keeping neonatal children alive? Have you ever had to do that?
No.
Have you ever had to make the decision as to which outreach clinics you were going to fund, whether you're going to continue to expand in Sarasota versus Pasco County versus Polk County? Have you ever had to do that?
No.
When you took over your company, you said it was in bankruptcy?
Yes.
Did you make changes to it?
Yes.
And as a result of the changes, did the company improve?
Yes.
One more.
I think it was a pretty good cross. I don't know if the jury's going to buy it. It's a pretty good cross.
Briefly on. Mr. Dees, were you deposed yesterday afternoon?
Yes.
How long did that deposition last?
15 minutes.
Were you asked any of the questions you were just asked you're challenging you in that way?
No.
Am I correct that the purpose of the deposition yesterday was just to find out what document you'd be relying upon?
That was the main, seemed to be the main question that got asked.
And you told them yesterday you'd be relying upon the 2021 tax form we looked at today, right?
Correct.
Hold on a second. I have on Zoom and now Miss Angela Green and others. So I'm going to do that.
A different witness is waiting on Zoom.
That's all right. Thank you. I don't know if I got the answer out there that I wanted, but you testified yesterday consistent with today's testimony that your opinions would be based on that tax return form.
Correct.
Since the residency training program was brought up, are you aware of the role that Dr. Sally Smith has played in this case?
Yes.
Objection, speculation, relevance, foundation.
Sustained.
You mentioned a concept there that was not explored that I'd like to explore a little bit, sale leaseback. Would you please explain, let's just be specific here. We're talking about real estate assets. What is a sale leaseback?
So now the plaintiffs are pivoting a little bit because I think it was a good cross and a cross that they weren't expecting based on the deposition. But now they're going to talk about how Johns Hopkins could potentially have even more money than they have if they do this sale leaseback thing. Thank you, Belinda, for gifting a membership and for all the new members. We've got Cat Queen, and now we've just got Cat as a member.
It's a huge industry in the United States. I get a phone call practically every week from representatives of investor groups that like to buy real estate and then lease it back to the owner. It's a way to raise liquidity if it's needed.
So it's
investors love it.
Is it a way to unlock value out of your real estate assets?
Correct. Get liquidity out of real estate.
And Chris Kraft, right? You receive these offers?
Yes.
And so if you were to enter into a sale leaseback arrangement, can you explain the mechanics of that a little bit more in detail for the jury?
Sure. The land gets valued by an independent appraiser. There's an advance rate against that value. So say the land value is $1 million. They'll loan you 80% of it. They'll pay you 80% of it and lease it back to you, giving a return to the person that buys the land and buildings.
And then you effectively pay rent.
Correct.
And so using those figures we discussed a moment ago, did we not an underestimate in terms of plants, property, equipment of $400 million?
Yes.
And you believe that'd be significantly undervalued?
Yes.
But if you're able to unlock 80% of the value of those real estate assets, considering that it's $400 million, what are we talking about? What number?
Easily 75% of that number.
And so that'd be $300 million?
Yeah.
And if the hospital, Johns Hopkins All Children's Hospital, enter into an arrangement like this, they'd be able to continue operations in their hospital as it exists.
Correct.
You wouldn't be shutting down a children's hospital by doing it.
Objection, foundation, speculation.
Overruled.
You wouldn't be shutting down the children's hospital by doing this. Correct. That's important for the jury to hear. Maybe they want to shut them down. And if they want to shut them down, they could say $1 billion. Give everything you guys have to Maya. Would be wild, but
You wouldn't be shutting down a children's hospital by entering into a sale leaseback agreement, would you?
It would depend on the amount of the punitive damages, but if the sale leaseback paid the punitive damages, you could have all your cash on your balance sheet and keep it there.
And so if you consider the cash on the balance sheet of $600 million and sale leaseback income $300 million, what figure are we talking about that would be available to pay punitive damages?
Well, in total, you'd have the cash and the value of real estate.
And 600 plus 300 million.
900 million.
And again, are all your opinions?
that sounds good, right? The plaintiffs are like, 900 million sounds good. Does that sound good to you? 900 million sounds good. Whew, these numbers are huge. They're huge that Johns Hopkins has access to.
Reasonable management and accounting probability.
Yes.
Thank you.
Absolutely.
So just so we're super clear on this leaseback agreement that you think the hospital should enter into, that means they're selling the property.
I didn't suggest that. I said it's an option that could be considered.
Right. And
I'm not recommending that.
But if a hospital, if All Children's Hospital had to enter a
Oh,
leaseback,
dude,
that means they're selling
pause. Shapiro, you should have, he just said, I'm not recommending that. You should have gone with that. Why aren't you recommending that? Because it's bad for the hospital, right?
property that they own that they're not currently paying rent on to somebody that's going to charge them rent, right?
But it allows them to keep their cash investments, which you explained were badly needed.
Yeah, well, and that's going to decrease their balance sheet in terms of what they have to have going out the door for rent. True.
Correct.
And so, for example, if they had to sell $300 million worth of property and lease it back at say 8%, that's gonna cost the company what? How's your math? What, 24 million?
Yeah.
What's the cost of an MRI machine that can survey pediatric cancer and save children's lives? Do you
Objection
know?
to foundation relevance.
Sustained.
Do you know what the cost? Do you know what that 24 million could go to buy? How many lives could be saved by that?
Same objection.
Sustained.
No more questions.
Any follow-up questions?
No.
Members of the jury, do any of you have any questions?
The premise is that you guys have to be doing the right thing with the money. That's the premise that I'm not sure they're following. They're reviewing some jury questions here. So there's usually a lot.
Do punitive damages?
Here we go.
Jury has some questions, sir.
Kind of like being behind.
Where do punitive damages go?
Where they go?
Do you know who gets them? If you know.
They're paid to the plaintiff.
Next question.
So the jury doesn't understand where punitive damages go. And you know who else asked that same exact question? You guys, the chat. Where do punitive damages go? Because it's not perfectly clear. But again, you guys are a great representation of jurors. My Miracle Mama, thank you, Peter. And I think Maya and her family will be very philanthropic with this win. If the hospital settles later on, do appeals go away? Yes, usually usually that's an agreement that they're going to waive all appellate or get rid of the appeals. We're going to settle, sign a release, and be done. That would be awesome. I hope she does use the money wisely to help CRPS patients, maybe help different research facilities to find the best way to treat it. That would be awesome. Maria gifting out a membership. It's so cool.
Mr. Shapiro mentioned Johns Hopkins All Children's Hospital needs its balances, or that its balances are needed for upgrades, which brings me to ask this. I believe you said Johns Hopkins All Children's Hospital runs about 1.2 billion plus or minus on their tax balance sheets from year to year. Is that correct?
You need to be more specific than that. So if you look at line by line, we only had through 2020 available when I did my analysis. Since that time, like as recently as yesterday, I saw tax returns that were further 2022, for instance. The cash balances stayed fairly stable across all the years. So the argument that Mr. Shapiro made about they need that money to spend, there's no evidence of that in the tax returns. I'm not disputing the fact that he believes that, but the tax returns that I looked at, the cash balances are fairly stable from year to year.
Well, then the next question is, I would believe that Johns Hopkins All Children's Hospital has every year been making constant equipment upgrades, and with constant upgrades still keeps a floating 1.2 plus or minus billion on yearly tax balance sheets.
Again, you have to go into the lines themselves. The cash is the number that if it's the net number of what goes in and what comes out. So if you add the numbers up, it's fairly stable from year to year. So if they're investing in new equipment, which I can imagine they are, every business does, they're taking in sufficient cash to cover those costs.
Okay, thank you. Plaintiffs, any further questions? Defense. Okay, was there any further from the jury?
Actually, I have one more question.
Come on down, Mr. Shapiro. May this witness be excused? Thank you, sir. And your next witness, please.
For 1 second, session.
Sure.
All right. Let's see if we can jump past this break.
So is the plaintiff arrests its punitive damage case? Okay, members of the jury, we're going to take a few minutes break. You may not discuss this case amongst yourselves. You may not do any investigation. You may not
You got to
receive-
figure out what exhibits the defense wants to bring in. So that's why we're going to take this break. Eventually, we're going to have to pop off here. I'm going to be working late tonight, catching up on all the stuff I missed, or I was only planning on going for 30 minutes. It's been over 2 hours here.
any information. Let's go ahead and just take your break, and then we'll call you back and try to hopefully within 10 minutes or so.
All right. Jurors, I say.
Jury's exhibits that we can talk about.
I think we're going to use
Okay, so we're not going to do any additional exhibits. And did you get those additional clips from the plaintiffs?
Not that I'm aware of it. We're saying, Your Honor.
They were sent.
I gave Mr. Control the file.
While they're taking this break, if you guys haven't subscribed to our channel yet, hit that subscribe button, please. We are so close to 300,000 subscribers. Hopefully we can get there before the end of the year. If you haven't subscribed, let me know if you're new from this case, and hit that like button if you haven't already.
Files on their hard drives.
Okay, so what we're going to do is we're going to take a 10-minute break. So if you want to look at those extra clips, you can do that. Mr. Altenberg.
I don't think I have a hard copy of the instruction and verdict. I just look at the final change on that.
What I'll do is when I come back, I'll bring a copy, and if you can fly spec it. And I think we emailed it, so Mr. Elliott probably would have the ability to look at it as well.
Your Honor, I'm not sure I've seen that one change we made on the verdict form. Let me see.
I did not. You're right. I did not resend it after the one change that you made. So in a couple moments, I will resend that, and then I'll bring Mr. Altenberg a paper copy when I come back from break.
Thanks very much.
Okay, anything else before we go on break? Okay, let's try to keep this to no more than 10 minutes, folks.
All rise. Court in recess.
All right, let me jump ahead here. We're about 5 minutes behind, so we will wait for it to come back. I'll answer some questions. Lady Losandra, if more patients are affected, consequences. So no, unfortunately, you can't go back and punish them more if they continue to do this. There can be other lawsuits, obviously, and things like that, but not automatically. No, does it just go up? Why did they ask for a mistrial, Miss Bodette? They said the word insurance, and that's always a bad thing to do in trials in Florida, unless, of course, it's an insurance claim for underinsured motorists or different times. Asia, Peter, time is just a construct. Go Cards. Yeah, I wish that was the case. I feel like I have no time lately. Bodie, don't do things that get big settlements against you or big verdicts against you. I agree with you. I very much agree with you, because guess what? If you do, then there's going to be a big settlement or verdict against you, as there should, until you stop or are unable to do the thing that you do that creates these problems. Marlies, the kid's reaction when their mom got vindicated broke my heart. English is a second language. Hope that came out right. It absolutely did. And I agree with you. I mean, that's what really set it off for them, is they wanted to know, again, validation they probably need to deal with on their own, but to have other people telling them, we agree with you that this is the only reason your mom did this, or the main reason your mom did this. And it wasn't because she didn't care about you or didn't want to be there for you or anything like that. She did it because of this, because they pushed her to do this, because their actions were, whatever the verbiage was, the driving force behind it. I mean, that's got to mean a lot to you. And legally speaking, that is the decision that this jury made. We've got so many new members, which is, you know, so fun to have new people join the experience and bring their background and their thought process to the group here, which is awesome. All right. Azam finally caught up. Now I sound like I'm on slow-mo. The jury questions have been epic. Yeah, they gave this expert an opportunity to say, yeah, you know what? I disagree with Mr. Shapiro's argument because the cash is the same year over year. I'm Maddie. Great that your subs are better than much of the internet, though some people on here get mad and block because they disagree with one viewpoint. They don't see the irony. SMH. Well, we try to keep it positive regardless. of if we agree or disagree. I think sometimes the way we agree or disagree can be important. Kind of like the lawyers have been perfectly fine for most of the trial, but once in a while they get a little disrespectful with the judge. The judge expects arguments, expects lawyers to argue. It's what we do. But honestly, respect is always most important. Peter, do you think the defense would win an appeal over the word insurance? No. I don't think it had any, it's going to come into play at all, especially because insurance doesn't cover this stuff and the judge instructed the jury of such. Stephanie, is there any truth to this? However, if anyone mentions that the defendant is covered under a policy of insurance, it is a mistrial and the attorneys will have to redo the whole thing with a new jury. Generally, this can happen. It is not something that happens all the time. There are ways that you can try to cure it. In a normal car accident trial that you're suing Miss Jones, if you say Miss Jones has insurance, usually that will cause a mistrial. This is a very different case. We're in a very different part of the process. So this like bright line rule is not necessarily in effect for this case. I think the judge handled it perfectly appropriately. That's exactly how I would have wanted it handled if I was an attorney in the case and how I would have handled it if I was the judge. Yeah, 88 Jeeves. Yeah, I mean, he should have. But again, usually most experts that do this a lot know they can't say that. He seems like he probably doesn't do a ton of, testimony and PI cases. So maybe he didn't know. How much will the attorneys get from the award? A lot. Probably somewhere around, because it's a sliding scale on percentages, unless, again, they have some kind of agreement where it's 40%, 30%, 25%, 20%, whatever. My guess is somewhere around 25% of the total, maybe less than that. Maybe somewhere between 20 to 25% of the total amount is probably what the lawyers will end up getting, because that 40% is only for the first million in most cases in Florida. Total amount awarded was over 200 million, but again, we're not done yet because there's still punitives. Welcome, Tammy. Sorry, Tammy. I know a Tommy Shelton, and so I just automatically read Tommy. Sorry, Tammy. Yeah, Stacy, I've reviewed a lot of nonprofit tax returns. If they have unrealistic salaries to the officers, that's a huge red flag. I mean, yeah, let's be honest. The money's got to go somewhere. They're not building a new hospital. I mean, $1 billion? Like you're reinvesting $1 billion? Come on. Thank you, Mara. I'll do my best. Do my best. Michelle Z, I'm late coming in. I wish they would have shown attorneys for the defense. I'm still wet in the eyes. Go CRPS warriors in this chat. Yeah, and there are quite a few. Quite a few.
And Mr. Altenberg, I've got 4 copies of the verdict form and the instructions coming.
Yes, Nicole, 9,000 in the chat. Wild. Will you guys?
Where'd all the plaintiffs' lawyers?
Yeah, you haven't.
Your Honor, do you see?
Well, I have all the plaintiffs' lawyers are out, so let's just wait.
I was just asking.
Judges, just even the appearance of impropriety he doesn't want. There's cameras recording, so nothing improper is probably going to happen. But he's like, hey, let's not do anything about the case till the plaintiffs' lawyers walk in. When you start to get to know judges and judges that do this, you trust them. You feel like it's fair, even if they call it against you, which has happened. Hunter Carroll has absolutely made calls I disagree with that I wish would have gone differently. So I don't want to make it seem like that, but he's thoughtful and smart and does his best to make the right call. And as a lawyer, you're never going to agree with every call a judge makes. Thank you, Megan. I'm trying. I don't do it a ton, and it's tough for me, man. I'm
in the waiting room, and I have a Miss Rogers.
My schedule is usually packed doing 2 things at once. So it's hard for me to get this big of a chunk of time. Really sad thing happened today that opened up a block of time that we don't have to get into. But my plans got canceled for this afternoon. because of a literal tragedy, but that doesn't mean work didn't stack up, but I can get to it after, especially no stream tonight, right? John, you're the best, man. Speaking of somebody who disagrees with me all the time, still love him, and he's still welcoming people in. Hopefully not more people in his team of disagreement. I'm just kidding.
Sharon Rogers.
Yes, sir. We were told just before this started that they would not be calling this Green, and they would only be calling this Rogers.
Well, I have both of them in the waiting room, so
Ms. Rogers will be first.
so you're calling both?
I believe Mr. Hunter doesn't intend to call this Green.
I'm sorry, does or does not?
Yes, does.
Okay. And so everyone now has a copy of the jury instructions and verdict form, and I'm trusting that both plaintiffs and defense will fly spec it again while we are in the defense
So
case.
Green is the one they already deposed. Green and I think Rogers are on. Well, whatever. Here's the point. We'll see who testifies when they take the stand and testify, right?
Too much stuff here.
It's going to be tough for me to listen to this on just normal speed. Susan, if they settle, can this case set precedent around J-Hatch causing emotional distress to Beata? Potentially, or any of the other issues that have been brought up. It can, but I think this was a very specific issue that was compounded with 90 days basically of problems. It wasn't just one time somebody patted her or, said something mean or whatever. There was so much that went into this that I do think it's probably going to be an outlier and an exception, not the rule. But we'll have to see how it all kind of plays out.
Are we ready to bring the jury back in?
Yes, sir.
From the plaintiffs, are you ready?
We're ready.
We don't have the jury here. Do you need to approach or can we just talk?
Rachel said, sorry, this sounds ignorant, but why would the mention of insurance cause mistrial? Because the insurance company doesn't want people to know there's insurance, and they pay a lot of lobbyists to make sure that rule is intact, because they think if you hear somebody has insurance, you're like, oh, it's not money out of their pocket. Insurance will pay for it. That's what insurance is for. And you'll be more likely to award verdicts in favor of the plaintiff. That's generally why, in my opinion. More and more people gifting memberships, which is crazy. And people that are just so invested in the channel is so cool. I appreciate you guys.
We were given a number of audio
Clips, files.
Whatever they're. We still haven't been given the video files that we saw the other night. I think you're right. Okay. What we got was copies of what Your Honor admitted or ruled upon, and then we got audio, not video. So I think I can proceed with what I got, but it's not.
Well, how about this? Can I have everyone's attention from the plaintiff's team?
My apologies.
Why don't we do this? Why don't we start with the defense case? In the interim, the plaintiffs will re-give the video files. And before you rest, Mr. Hunter, I'll send the jury out and then you can go look at the video files. Does that work?
I guess so, Judge.
Or do you want to?
I'm just concerned that we're going to get blamed for delaying this, given the hour and given the day and where we are.
Okay, well, then if you want to do it now, we can do it now, and I'll keep the jury, and the jury won't know. So.
Objection what Your Honor was doing, but I do want the opportunity to look at these things, and if indicated to put a clip or three in, and we've got a problem with the prejudice that is being inflicted on us, given our position in presenting these things, and the potential perception that a jury that's already not particularly pleased with us is going to blame us for keeping them later.
Well, you tell me, do you want to do it now, or do you want me to send the jury out after you have finished with your two witnesses?
I think the two witnesses, Judge, we may make the decision that we'll go without. But
and Mr. Altman is trying to get in your ear.
I need to see.
Did whatever Mr. Altenburn just talked to you change your?
He was asking, and I thought of it. He was asking if I could step out and watch it while Mr. Shapiro is putting the next witness on. And what I told him was that I wanted to see what the next witness said, so as not to have overlap with the second witness we're calling.
Understood.
Yeah. We had requested to review the 2 boxes of additional materials that were not provided to us at the deposition of Ms. Green. We have yet to receive those.
I thought those were being brought this morning.
They were available here at the courthouse about the time the jury knocked.
So they're still available?
believe so.
So someone can go out and look at them in the hallway or in one of the witness rooms?
We'll do that. Where are, if we can know where they are, please.
Or defense, where are those
They're
spots?
in one of the mediation rooms, Judge.
Do one of
Our
the
paralegals can do it.
paralegals, can you help the plaintiffs? And then from the plaintiff side, let's talk about those extra clips. Are we getting those in a position so that, I need the plaintiff's attention. Are we getting those clips that were not played here in court?
So frustrating, right? I mean, you can see how frustrating it is trying to get stuff. He's like, we could have had him at our depot. They didn't give it to us. They made him available today in court, and they're accusing us of trial by ambush. Canonical Heat is also gifting memberships. This is wild. Yeah, you have to turn gifted on, I guess. I don't really know how that works. Usually the chat explains it better than I can.
Or they need to see them.
I
So
understand. It was nothing intentional. We had some confusion. We are providing the full video clips that we have. There.
and how are we doing that?
Mr. Reyes is preparing a thumb drive with the full video clips we received, and he will have it to them momentarily.
Are we ready to bring in the jury at this point?
Yes, Your Honor.
Plaintiffs?
Yes, Your Honor.
Let's bring in the jury.
Thank you, Shanna. Netwoman, dumb question. Do you know how, like percentage or set amount, that the hospital's lawyers are paid when they lose a case? So the vast majority of defense lawyers, criminal or civil, get paid either a flat fee or hourly. Criminal is more flat fee than hourly. Civil is more hourly than flat fee.
Members of the
They're
jury, I want to
billing-
confirm while you were away, you did not discuss this case amongst yourself.
If they're billing $500 an hour and they lose, they still get paid $500 an hour. Now, sometimes insurance companies or companies in general will slash attorney's fees because, you know, they'll be mad or don't want to pay. And if it's one of your biggest clients or one of your only clients, you kind of just have to sit there and take it if you're the lawyer. But you get paid win or lose, because if you had to win, they probably wouldn't take this case. L, thank you for gifting memberships. I've got to go grab a drink. Mine is out, but I will be right back as he tells the jury, hey, you guys haven't talked to anybody, have you?
You did no investigation and received no information. Is that correct? No one from the media approached you. Is that correct? Or actually, no one, whether they're from the media or elsewise, no one approached you. Is that correct? And you haven't seen any media clips. Is that correct? Defense, your case.
Yes, we call Sharon Rogers. She's my video.
Oh, and what state is she in?
She's here in Florida.
Okay. There we go. I had the spotlight. And Mr. Cottrell, are you going to be able to? There we go. Good afternoon, Ms. Rogers. This is Judge Carroll. Can you hear me okay?
I can. Can you hear me?
Absolutely, Ms. Rogers. And are you currently within the state of Florida as you sit wherever you're seated?
I am not.
You're outside the state of Florida?
I am, yes.
Okay. Let me give you an instruction. I am a judge in the state of Florida, so my powers, if you will, only go to the border of the state of Florida. Now, you may allow me to administer the oath to you, but if you allow me to do that, you're going to agree that any sort of action for perjury would actually occur here in Sarasota County, Florida, because that's where you're actually testifying, even though you're not physically here now with us. So understanding that and agreeing to personal jurisdiction here in Sarasota County, Florida, do you agree I can administer the oath to you?
Yes, I agree.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you give is the truth?
Yes, I do.
Okay, go ahead and lower your hand. Thank you very much. And I have Mr. Shapiro in front of me who's going to start the questioning.
Thank you, Your Honor. Can you please introduce yourself to the jury?
Hi, I'm Sharon Rogers.
And what's your current position?
I serve as Vice President and Chief Financial Officer at Johns Hopkins All Children's Hospital.
Okay, I'm going to take you back a little bit. Can you tell me where
Seems
you
like the right person, the CFO, right?
Graduate education.
Sure. I attended Indiana University in Bloomington, Indiana.
And what did you graduate with?
Bachelor's degree is in psychology.
Okay. And then did you obtain any other schooling after that?
Yes, my master's degree is also from Indiana University.
And what did you get your master's in?
My master's degree is in information science.
Okay. And did you eventually make your way to All Children's Hospital?
I did, yes.
And what year did you start at All Children's?
In 2022.
Okay. And what do you do in your current role?
I have responsibility for our financials.
Okay. And when you say financials, what do you mean? If you could explain that a little bit more.
Sure. I handle financial reporting, budgeting for capital and operating. I work to ensure our teams understand how the financials impact the organization. I work with our executive teams to help ensure our financial decisions are grounded in data and produce operating statistics for the organization.
Is All Children's Hospital a charitable foundation?
We have a charitable foundation.
In terms of your filing, how is All Children's organized?
That was
Maybe if you can
weird. She
explain
said,
what
we have a charitable foundation. It's like, but the way you file it, the answer to that is yes, ma'am. I wonder if the defense provided a 3-page outline to her.
501c3 is.
Yes, we are a nonprofit organization. So we are here to provide care for the community. We are here to provide care for all members of the community. Of course, we're focused around pediatrics. We provide care for anyone who needs our care, regardless of payer or ability to pay.
Let me talk to you a little bit about that. Are you generally familiar with what the payer sources are for the children that you serve?
Yes, I am. Our payer sources, many are familiar that there are multiple types of payer sources, government and non-government. We are 61% Medicaid as our payer source, 35% commercial, 1% self-pay, and 3% other.
So in terms of Medicaid, the majority of the children treated at All Children's are Medicaid funded. Is that correct?
That's correct.
Okay. So when you're dealing with a Medicaid patient, are the reimbursement rates from Medicaid sufficient to pay the expenses that All Children's incurring to pay for them?
They're not. Medicaid is by far the most challenging payer. Does not cover the cost of providing care. That is pretty well known across the industry. So Medicaid covers roughly 70%.
It's so funny to hear this. Funny is maybe the wrong word, but in all of our cases, defense attorneys are trying to be like, yeah, Medicaid prices is what you should award for future medical bills and past medical bills. Medicaid? Come on. What about Medicare? The biggest payers in the United States. Let's award those amounts of money. But everybody actually knows they're actually paying nothing, and no doctors would be able to live basically if all they did was bill Medicaid. That's a side tangent. Sorry.
Or 70 cents on the dollar for the care that we provide. And given it's 61% of our payer mix, that has a significant impact on us.
So what happens if a child in need of medical care comes into All Children's with Medicaid? Do you still treat them?
Oh, absolutely. Yes.
And
the overages is what covers that. And you're just taking money away that could help other children. I think this is a good argument. I do. You guys let me know.
what if there are medications that the child needs that Medicaid doesn't cover? Do you still provide them?
We provide medications, yes.
And where do you come up with that revenue if you're losing money on that?
We, all hospitals do their best. We are very uniquely poised because we have such a high Medicaid population. So we have fairly narrow margins. We, try to very efficient with our teams using industry best practices. We do our best to be efficient and resourceful to ensure that we can provide care for all patients who are coming in need and are in need of our care.
Let me ask you a little bit about a document that was shown to the prior witness. Do you have the 990 tax return in front of you, Ms. Rogers?
I do, yes.
And I'll put it up on the screen. It's Trial Exhibit 2279H. And for your
What's happening now is the defense is presenting their evidence and punitive damages as to why you should not award a large amount of money against them.
purposes,
Because they're so good. You notice they're not talking about any of their actions with Maya anymore. But they're specifically saying, like, we're so great. We're nonprofit. We help kids who can't afford it. That's where all the money goes. So please don't take that money from us, basically.
Ms. Rogers, I'm going to turn to the second page. We'll put it on the screen as well. I want it 2279H-002. Okay.
Sorry, I had not enabled Mr. Cottrell to do that, so that was my fault. I'm sorry.
No problem. Can you enlarge that a little bit, Clay? Okay, and scroll down a little bit. There's total revenue lines. You see at line 12, the revenue for the year. Are you able to see that, the 544?
Yes, okay.
Yes.
Yes, I see it now. Yes.
Okay. And there's for the prior year and the current year. Do you see that?
Yes.
And then, for example, in the prior year of this tax return, what was the revenue?
Prior year's revenue was $544 million.
And what,
$192.
and what were the expenses?
Prior year's total expenses, $563 million.
So did the hospital run a shortfall on revenue in the prior year of 2020 of almost 19 million?
Yes.
A short.
And was that the year that was COVID? Is that right?
Meaning they made negative 19 million.
The prior year was the start of COVID.
Okay. But the hospital keeps its doors open even though they had outspent what they took in. How do you do that? Do you tap into reserves or what's the function?
Yes. So the hospital kept its doors open. We did have to tap into reserves during the early period of COVID. We continued to provide care for the community. There were a lot of expense increases, not only in the early days, but especially in the periods following COVID. Volumes dropped significantly. So there were a lot of adjustments that had to be made, not only in the beginning of COVID, but a lot of adjustments had to be made afterward as well.
Let me ask you about the line 8 contributions and grants. What is that?
That represents primarily two items, one being a Healthy Start, which is a grant that's received, but in large part, it is provider relief funds, which is our CARES Act, which is a federally provided fund that was given to many hospitals across the country to help support the period of the pandemic.
Did that CARES Act money, that 33.447 million, did that continue into this year or is that now gone?
That is now gone.
So that was a one-time funding from the federal government during the period of COVID?
That's correct.
Let me ask you a little bit about the capital, the $19 million in capital that's spent.
Inflates that year because of the funding for COVID, but doesn't change the $1.2 billion.
Take that down for now, Clay. What does it mean to spend money on capital improvement?
Sure. So like any large organization, you want to reinvest in the organization in order to keep up with routine maintenance, not only with routine maintenance, but you want to also be able to strategically invest. In most organizations, you want to be able to keep up with the rate of depreciation. We spent $19 million in capital this year, in the year that you're talking about. That does not keep up with the rate of depreciation. That was to handle some general routine maintenance. You want to make sure that everything from roofs to HVAC systems to elevator equipment, that you are keeping up with those things so that you don't get into problems down the line.
Okay. That money is used to ensure safety at the hospital. Is that right?
That's exactly right.
Now, in terms of the jury has seen that there's about $500 million in potential investments that the hospital keeps on its balance sheets. Can you tell the jury what's that for?
Sure. So any large organization needs to have a healthy balance sheet. We are no different from needing to have a healthy balance sheet. That balance sheet and those investments are, well, one, having a healthy balance sheet is important. Credit.
Yeah, no, this does nothing for me personally. This part, they should have a healthy balance sheet. Nina, Peter, does this judge have RBF in general or is frequent look of contempt reserved for this case? This is also why it's tough for me to stream these cases. I get really bored because I'm used to listening to this stuff on 2 times while I'm working at the same time. So just doing this is kind of tough for me. No, I think what he's trying to do is not let his emotions come through. He doesn't want to seem biased to either side or happy or mad if somebody's talking. So I think that's why he's doing it. Megan, hi. When do you expect the jury's decision on this? I thought they wanted to get all this done today. So if this is, they talk about maybe they'll call another witness, maybe they won't, maybe they have some things to play. I think if they're done, then they're going to do closing arguments, 15, 20 minutes each, and then they may give it to the jury tonight, but I don't know. I would expect this is going to go into Monday, but I don't think they would love that. Dorothy, I'm 71 and Medicare covers very little. Most all medical expenses go to my secondary Blue Cross Blue Shield that I pay for a lot for monthly. I agree with you. And I have so many clients that deal with the same thing. And they're just like, oh, Medicare, just bill Medicare. That's fair. Medicare rates are fair. Doctors are like, no, you can't get in immediately for this kind of treatment for a traumatic event on Medicare unless you just like go to the hospital. Jojo, the negative revenue in 2018, 2019 can be attributed to the board change that needed to pay leave bonuses. Yeah, that's true. I would ask that if I was a plaintiff, or I would love to have you sitting next to me and hand me a little sticky note to say, why don't you ask him what happened in 2019? That little IJ, that made it more difficult for you guys to make money, right? Kelly, as a mom to a special needs cancer patient who in the last year has been admitted to no less 3 times per month, I will never take my child to JHATCH. Dr. Barr was a witness and I won't let him near my child ever. I will reserve my thoughts on this, but thank you for the comment. I'll just say this. My mom used to say, when a lot of this stuff started coming out, she's like, if she had a broken leg, she would hop past Johns Hopkins. Shelly, CPA who does CFO work, you structure your client mix so your margins plus other cash inflow covers your outflow. Nothing she's mentioned is abnormal. I agree.
Auditors look at that. If we are going to borrow, they want to ensure that we are fiscally sound. Having a healthy, having access to investments allows us to continue to provide care to the community that helps us uphold our mission. So not only those routine investments, strategic capital investments, but large strategic investments are really important. Every dollar that we have really needs to go back into the community. So that available investment pool is there for that purpose.
What happens if that amount gets depleted? Meaning, does that affect our ability to borrow money or credit rating agencies? Can you explain that, please?
Yes, if that money is depleted, that affects our credit rating agency. Absolutely, it affects us in the case of an emergency. I mentioned that during the period of the pandemic, we had to access and tap into that pool because of the emergency period that we were in. We wouldn't have access to that. Also, projects that are growing and extending our care to the children of our community who need us, that money is there for them, for those strategic growth projects that would allow us to expand our care.
Do you have outreach clinics in Sarasota?
Yes.
And if you know, do those operate at a profit or a loss?
So our clinics generally operate at a loss. This is pretty consistent where clinics operate at a loss.
Maybe approach on this last question.
Approach. Ms. Rogers, I'm going to turn off.
You can unmute, Ms. Rogers.
I've got to open up the microphones again. Ms. Rogers, go ahead and unmute yourself, please. Can you hear me okay now, ma'am?
I can. Can you hear me?
Yes, absolutely. Mr. Shapiro, you may continue.
Sure. In the year.
Belinda, people's lives are expendable for balance sheets. Welcome to profits over people. The most used slogan in closing arguments for personal injury cases.
For example, 2020, 2021, did the clinics in the outreach clinics like those in Sarasota operate at a loss?
Yes.
And where does the shortfall come from? Does that come from the hospital?
Yes, it's made up by the hospital.
Okay. Let me turn back to some of the sources of revenue at the hospital that may cover that shortfall. Well, let me ask you if you know, Susan, just to cover this. Do you know what the largest source of funding is in terms of program?
Our NICU is our largest source. We care for any of the most critically acute or sickest children in our community, and our NICU is by far the largest program and revenue source.
And we're all familiar, at least with the acronym. That's the neonatal intensive care unit.
Yes, sir.
Is that, if you're familiar, is that where babies go when they're struggling to breathe after birth?
Yes, sir.
Okay. And do you know, in terms of acuity, where All Children's ranks, at least state, local, in terms of what our All Children's acuity is versus other hospitals?
Like, to say how good we are, I don't get that theory. Like, the jury's not going to think you're great. I feel like we've already established that.
Yes.
Overruled.
You can answer.
We care for the sickest or the most acute babies in the state of Florida.
Okay. What about respiratory therapy? Is that another category that is one of the larger programs?
Yes, it is.
Okay. And what types of services does that cover?
Respiratory therapy is helping. It is also helping ensure that our patients and children can breathe effectively, and caring for inpatients in the hospital.
Do you know what comes next in terms of the order of funding sources, programs?
Our surgical care program is a very strong program as well.
People are asking, just jumping in, who she is. She's the CFO from Johns Hopkins. People are also asking about the attorney's fees again. In Florida, after litigation, assuming they did not admit liability, which they didn't, 40% the first million, 30% from 1 to 2 million, 20% from 2 million up are the attorney's fees. And because so much of it is going to be above that 2 million number, my guess is it comes out roughly to 20 something percent, low 20% is the attorney's fees.
Does that include both surgery for kids? Does that include children born in the neonatal intensive care unit?
Yes. Yes, it does.
Does that include children that have been afflicted with cancer and need surgery?
Yes, it does.
And are those programs, from your knowledge in terms of strategic planning, that All Children's is looking to expand if they have the resources to do so?
She's supposed to tell the other side if she's reviewing a document, but I don't know.
Yes, absolutely.
And do children, both those who are born with cancer and those who are born with congenital anomalies down in Sarasota, do you serve that population?
Yes, we do.
And do you provide outpatient clinics to make it easier for people in the Sarasota area to access your services?
Yes, we do. It's important for us that we are providing care to our patients close to where they reside.
Let me talk to you about the concept of money being fungible. Do you know what that means?
Yes, I believe I know what you're referring to.
So let me try to break it down. Every dollar that's spent on something, you have a pool of money. You can either spend it on patient care operations or you can spend it on something else. Is that right?
Yes.
Okay. So just to be clear, the money that's left over at the end of the year, is it reinvested back into the organization?
Yes.
And the money that's reinvested back into the organization, does it go into strategic planning to help sick children in the community, including those who have cancer, those who are born with congenital anomalies? Is that true?
Yes.
And we heard, you weren't here for it, but the concept of well, All Children's could just sell land and lease it back. Are you generally familiar of like sale leasebacks and what that entails?
I'm familiar with that concept.
That would cost All Children's money if they had to sell property and then lease it. Well, let me ask you: Would it lead
just
to
kind of
All
leading.
Children's having a negative cash flow situation relative to where you are now if you had to sell property and lease it back to yourself?
Objection, leading, vague, ambiguous.
Overall, she can answer.
That would take funds out of our operating income if we had to pursue that option.
And when you say operating income, the number one goal of the operating income is to provide.
Objection, leading.
Let me just ask you, what is the goal of the operating income?
Well, the goal is to ensure that we have money to be able to provide care to fulfill our mission, which includes caring for the community's most vulnerable children throughout the community.
Tracy, it's just this location. I'm pretty sure it's its own entity.
And that extends from sick children to, research, providing innovative care, ensuring access to drugs and therapies. As well as those capital, routine maintenance capital projects that I mentioned in strategic projects.
When you talk about strategic projects, as the CFO, does All Children's have the revenue right now to fund them all?
No, we don't. We have historically underspent on some of our capital needs and are assessing those now. Of course, keeping safety first, and have pursued the items that we absolutely need to. But there is a lot on the list of things that we both need and want to do that has not been pursued.
If All Children's were required to pay a punitive award in this case where the money left the hospital, would that cause you as a CFO to go to the strategic planning committee and tell them there are certain projects where you're trying to save lives in the community that now need to go on hold?
Yes, it would.
The guilt trip is a little too hard for Shapiro at this point. Again, I think there are good arguments, but I mean, he's trying to guilt a jury that feels bad for Maya. They don't feel bad for Johns Hopkins at this point.
Stop to those plans.
One moment, Your Honor.
Ooh, are we done? Whoops.
Cross-examination.
Yes, sir. Good afternoon, Ms. Rogers.
Good afternoon.
Thank you for joining us on short notice. Where are you physically today?
I'm in Indiana today.
Understood. Does Johns Hopkins have a hospital in Indiana?
No, no, they don't.
I'm curious to know who writes or who you're employed by. Is it Johns Hopkins All Children's Hospital or the system?
I'm employed by Johns Hopkins All Children's Hospital.
Understood. I want to discuss with you and this shouldn't take long. I want to discuss with you the tax returns that are in evidence. And I want to begin with what's been marked as 2279 Hotel. Mr. Reyes, if you could please publish or share. Rogers, just dealing with the technology.
SJ, I would have guessed more.
By the way, Ms. Rogers, while we're waiting for that, were you scheduled to attend a deposition at 1 o'clock this afternoon?
Yes, I attended and then was told that it was put on hold.
Understood. So you and I have not had an opportunity. I'm sorry.
Usually you can't ask questions like this
before, have we?
But let's see if he tries. Usually that would be inappropriate.
No.
Are we close?
I would say it's not relevant to punitive damages.
Ms. Rogers, while we're 2279 Hotel. While we're pulling that up, do you also have in front of you there the fiscal year 22 Form 990?
Yes.
Is there a fiscal year 23 Form 990 that's been filed yet?
'23?
Yes, ma'am.
Not yet.
If I understand correctly, the fiscal year for Johns Hopkins All Children's Hospital ends on June 30th each year. Is that right?
That's correct.
And so, just out of curiosity, what month is the latest fiscal year's tax return typically filed?
It is typically, you'll have to excuse me.
She's the CFO.
Because I will have to check. I am newer to the organization, so I don't know the typical month. I know we're finishing our audit for fiscal year 23 at the moment.
Understood. And yeah, thank you for reminding me of that. You joined Johns Hopkins All Children's Hospital last year.
By the
Beginning
way,
of last.
good side note, actually, interesting point there. So she's new. She can say she's new. She's only been there for a year. She doesn't know anything. She doesn't know when they filed those tax returns. She doesn't know when it's going to be done for 2023. She doesn't know what it is in 2023. Isn't that convenient? That this is who the defense chose to put on to represent Johns Hopkins All Children's Hospital. I can't tell you how many times I've taken a corporate rep depot and they pick somebody that doesn't know any of the answers. Somebody that's new. It's like, why? Because I think that's better for them.
Last year.
All right. And so you weren't around when the 2021 tax return was prepared, or the 2020, right? Ma'am?
I was in place to acknowledge it and review the 2021.
Oh, you were? All right. All right. Turning to what's in front of you, and can you see the tax return on your screen, ma'am?
Yes.
All right. If we would turn to the next page. And Mr. Reyes, if you would focus in on line 19 here. If you could zoom in on line 19, please. Do you see line 19, ma'am?
I do.
And so the $19 million loss that you discussed with Mr. Shapiro there, that was the prior year, correct?
That's correct.
And you discussed the loss at some length, but the next year, the hospital had a profit of $36 million, right?
That's correct.
And if we turned to the 2021 form, which would have been filed in 2022, just keep this here for now. The next year, you had a profit of $31 million, correct?
Yes, 30.8 million. Yes.
And so that year that we saw there in the 3-year trend that we have is the outlier, the loss of $19 million, right?
You have to consider it is not, if you went back to the prior year, the year before, the one that's shown with the negative 18, you would see an even more significant loss than that listed. And you have to factor in the one-time receipts of the CARES Act, the Provider Relief Act funds that we received during this period.
For the 2 most recent years on file, Johns Hopkins Children's Hospital had profits of $36 million and then $31 million. Am I correct?
Yes, we received over 60.
But at some point we lost money. So it's like, yeah, but 30 million over the last 2 years, just in profits. That's not having to cut anything, basically. You wouldn't have to cut back anything if you paid the $36 million or whatever over the last 2 years.
$1 million in provider relief funds.
So the 2 most recent years on file, Johns Hopkins Children's Hospital has been profitable.
By the way, I just thought of something. So that insurance comment, that insurance does not cover punitive damages. The judge told them that. Now, if I was a defense attorney, I would argue, but they did just hear the word insurance. So now they're thinking insurance is going to cover the compensatory damages that we already awarded. So punitives is going to be above and beyond that. When in reality, that might not be true either. Just interesting thought during this boring testimony.
Correct?
Correct. With the inclusion of the provider relief funds.
Understood. And the hospital wouldn't end up with a $600 million cash accounts and cash equivalent balance if it had been operating at a loss over its history, would it?
No, not if you look at the history in total.
All right.
If you look at the recent year's performance, the hospital has had very challenging years, and you would see that the operating margin has been very much challenged.
So $30 million profit and $35 million profit, you would characterize those as challenging years?
Yes, absolutely, because the revenue that is leading to that bottom line there is a one-time, not something that's sustainable. And so, like with any of our families or home situations, we want to be able to have income that we can depend on. And those one-time provider relief funds and CARES Act payments aren't something that we can continue to rely upon into the future. Those were temporary infusions that we received during the pandemic, which was obviously an outlier period. So those are very unique circumstances.
I'll move to strike the answer to the extent it was non-responsive.
Overruled.
Ma'am, over the history of Johns Hopkins All Children's Hospital, it has on more years operated at a profit, leading to a $600 million cash and cash equivalents balance.
Like, duh. If you're losing money every year, you don't have $600 million just sitting there. Lahaina Knoll, thank you so much for this. Mahalo. Merely, it could be if they, started digging into certain things, but usually the salaries and the overhead and things like that are not part of the punitive damage analysis. So Megan Bell, I thought she did the job they needed her to do on direct. She doesn't know a ton, and she's doing a decent job on cross, but it's just so boring. Not going to be incredibly effective, I think, to move this juror. So overall, not very effective.
Balance as of 2020, correct?
Well, to clarify, when you speak to the history, the entire history of the hospital.
Angela, I kind of think this is exactly what they're going to do.
I can't go back to the entire history of the hospital. But when we're looking at our recent performance and decisions that we're making now based on our current operating margin, we have to look at how we're performing right now and how we performed in recent years in order to determine what decisions we're making now and what free cash flow looks like right now. And that's been challenged.
Mr. Reyes, if you could turn to this same document, what Mr. Heath referenced, which was labeled in the top corner, page 9. And I think that's page 11 or 12 in actuality. Perfect. Nope. I see that. Can you scroll forward and back a couple pages? I'm not sure.
I don't like to jump the gun. All right. I don't like to jump ahead, Megan. We'll have to just wait and see what happens. We'll wait and see what happens. I won't say no, though.
Next. Back. If you could display that page, please. My apologies, Ms. Rogers. All right. You recognize this as the all children's balance sheet as reported in 2021?
Yes.
And is it accurate that after factoring in depreciation, the book value of the land, buildings, and equipment held by Johns Hopkins All Children's Hospital was $400 million, just under $400 million as of 2021?
Modern day technology, Lulu.
Yes.
And would you agree with me that if you look at the figure $651 million and change, that the $400 million we see reflected in terms of book value of the real estate significantly underestimates the market value of land, buildings, equipment as of 2021?
I can't speak to that.
You'd agree with me that the value before factoring in depreciation was $652 million approximately?
Your question is?
My question is, ma'am, in box 10A, before you factor in depreciation, which is a tax concept, is it not?
It's not the best question. Like, it's a tax concept, is it not? She doesn't have to agree with that, but the jury should get his point. Dog lover, can you please answer what the limit of you suck damages, aka punitive damages? I know it's 3 times more than the other damages, but what number is that? 57 million, I think, is what we added up for the battery and the false imprisonment, where punitive damages were checked. Yes. So 3 times 57, I think we said it was 171 million. So that would be if there is a cap. But there is a question on the jury verdict form now that they could answer that there was specific intent to harm Maya and that harm actually resulted from this. And therefore they could remove that cap altogether and give however much money they want. Belinda, why are hospitals for profit anyways? Well, it's a not for profit, but what that actually means has been twisted over time.
It is.
That the value of the buildings, equipment, and land was $652 million before depreciation.
Yes.
Have you, since you've been at Johns Hopkins All Children's Hospital, has the hospital had the value of its real estate between land, buildings, and equipment appraised?
Doubt it.
In total, I would have to verify.
The answer is no, but that's what's so annoying. She's not even going to answer.
I would have to verify that. I'd have to defer to our operations team.
Do you have an estimate of the?
In about every single piece of land, I'd have to validate that.
But in your role as CFO, do you have a rough estimate of the appraised value, market value
No,
of the land, buildings, and equipment currently held by Johns Hopkins All Children's Hospital?
I would prefer not to provide a rough estimate.
Why is that?
I don't have a rough estimate to provide to you.
You're not familiar? All right, moving on.
I'd prefer not to provide a rough estimate. It's like, why not? Well, because I don't have one.
Line 11, publicly traded securities. It's accurate that as of 2021, Johns Hopkins All Children's Hospital held approximately $518 million in publicly traded securities.
That's correct.
What are the top 5 holdings of Johns Hopkins All Children's Hospital in terms of public securities?
I'd need to validate that.
She doesn't know the answer.
Would they be Dow stocks like we would expect, Apple, Google, Microsoft, et cetera?
No, we have complex, we have, just like any organization, we have investment portfolios that are managed. So it's not individual stocks.
That are also huge.
Are you aware, even through your investment vehicles, what the top 5 holdings of publicly traded securities are?
No.
No, not with individual companies.
If we look at the category of investments program related, and I see $24,265,000, what are we talking about there?
On
line 13, man.
Okay, that is I apologize.
Thank you for apologizing. Thank you.
Those are our board designated investment holdings.
Can you give us an example or two?
Um, I'm not sure what you're looking for.
Oh, well, you just mentioned they were board directed investment holdings. I was wondering if you could give us what those would be in concrete terms. What does that mean? What are they?
No, I don't have the names of the funds.
And then
I don't have the names of the funds written.
Understood. And line 15, other assets of $46 million. Do you see line 15, Ms. Rogers?
Yes. Yes.
Well-
And I'm sorry, 13, those are board designated funds used that's for the debt service.
Understood.
So those are for debt service use.
And then $46 million on line 15, other assets. Do you see that, Ms. Rogers?
Yes.
What are we talking about there? What types of other assets?
Bless you, Katie. In a time such as this, to throw out 5 new memberships as we trudge through this testimony. I can't imagine how often I would do this if I stream trials, which I never will, like ever. But I actually did want to watch the entirety of this punitives thing to see how they did it with bifurcation and calling witnesses to testify through this stuff. So I did want to watch this anyways. So I'm suffering through this with you all. Yeah, her answer, her having I don't know as an answer is by design. This is not, they're not going to be mad about this. They're not going to be shocked. They picked her because she doesn't know a lot of this stuff.
That is lease, right of use, prepaid inventory.
Are you finished with your answer, ma'am?
Yes.
All right. And would you agree with me that as of the filing date here of June 30th, 2021, Johns Hopkins All Children's Hospital held total assets of $1,163 million and change?
Total assets, yes.
Nothing
As
further
reported there.
Nothing further this time. Thank you.
Any redirect?
Briefly. The, Ms. Rogers, you there?
Yes.
Okay. When Mr. Whitney was asking you about income of 36 million, 31 million, that all goes back into the hospital. It's not distributed as profit. correct?
Overruled.
That's correct.
And so, in other words, if All Children's is able to operate at a profit, they take the money back and devote it back into patient care in the community. Is that right?
Yes. All of the money goes back into the hospital in order to expand programs, extend programs, compensate team members, compensate providers. All of the money stays within the hospital. Goes back into patients.
And every dollar that you don't have available, whether it goes out in a punitive
We already
damages award
heard
or otherwise,
this.
is a dollar that All Children's does not have to fund patient care, including helping children struggling
Yes,
to
it's
breathe
just a
in
black
neonatal
screen right now.
ICU, children with cancer. Is that true?
That is true. Yes.
Thank you.
Anything further, Mr. Whitney?
No, Your Honor.
Hold on a second, Ms. Rogers. Let me see if the jury has any questions. There's going to be a jury question, so just hang tight. Ms. Rogers, I'm going to mute your microphone. Okay.
Yeah, listen, net woman, we can't, just because she's the CFO, we can't expect her to know everything about the finances. Okay. She's only the chief financial officer. Who would have thunk? Jury's got questions though, as they always do. They didn't have a lot of questions when they were deliberating though. I think they knew exactly what they wanted to do. My guess is it was just hard for them to figure out how much money is going to go in each section. This is a punitive damages portion or phase of a trial that was bifurcated. All right, we are all caught up, so I can't skip ahead. They took her off screen so she can look at the paperwork. Bifurcation, good question. What does bifurcation mean? Bifurcation means you split the trial into two trials where you have the actual liability and damages phase. And if they're going to award punitive damages, and if they are, you have that separate and second. Sometimes you can bifurcate liability, like whose fault is it? And you can bifurcate it from the damages. So first the jury determines who's at fault, and then they determine the damages in a totally separate trial. Sometimes you do that to save time or money, or if the damages are so bad that you think they're just going to say yes to liability because they hear how bad the damages are, you split it for that reason because the damages are so prejudicial. So there's different reasons to bifurcate or split trials up. Welcome to Carol and Christy Jenner. Oh, he's like, I wonder if they're going to say like, let's call it for the day. Peter, I'm behind on the case. Are they for Maya? About as for Maya as you can be. Almost as for Maya as her attorneys are asking for $238 million. I think they gave 210 plus. Callie, let's look at officer salaries. I'd be interested to know. Probably not relevant to punitive damages, but I'd be interested to know. Karen, welcome. I think they already figured out what's happening with the jury. I think at this point they are just trying to figure out if they're going to stop for the day, would be my guess. Richard, I know this is an important part of the case, but I imagine it'd be nerve-wracking for Maya. Generally speaking, does she or someone in her position have to be there today? So she was here for the verdict. She probably stayed thinking it wasn't going to be that long, although they did reserve 5 hours for it. But I mean, they didn't take the full 20 minutes for opening. They definitely didn't take 90 minutes for their case in chief. And they have 30 minutes each for closing. But I don't think she's that, nervous. Would you be nervous if you already got $200 million awarded and they believed you and they answered yes to all the questions you had for them and they looked over at the hospital and said no? I think most of the nerves have probably subdued at this point because the main thing that was causing her anxiety, she won. Belinda, happy to do it. Don't feel like I've provided a ton over the last witness because it's a struggle to get through. Paige, welcome. And Melissa, tons of new members. Gosh, this is going to be fun tomorrow. 10 a.m. Eastern. Members new and old come. Everything is probably stressful. All litigation, all trials are stressful for Maya and her family, but I got to be honest. If I was them, I would be so relieved at this point, a breath of fresh air based on that jury verdict. Welcome, Christine.
What in the world is that? Oh my gosh.
There was this bug that had a huge, I think it's a roach, that had a huge thing of dust on it. It looked like a monster
Rogers, if
coming
we could go
towards me.
ahead and
Holy
have you
cow.
unmute.
That was crazy.
Are you able to hear me?
I can.
There's a series of questions.
Oh, I just put my arm
Based
in
on
the
what I
dust.
heard Mr. Shapiro comment on about the 2020 Johns Hopkins All Children's Hospital tax return, which is the only tax return this jury has been allowed to view. In 2020, you basically lost money between what you took in and then what your expenses were. Is that correct?
Between 2020, yes.
You pointed out that this was a COVID area year. Therefore, your income was not that of the non-COVID years. Is that my understanding of what I believe you were stating?
Can I restate your question to make sure I'm
Yes, you may.
okay? So this was a COVID era. So this was, our income was not what we were used to. That is not exactly correct. We are not a hospital that has high margins in a normal year. Because of our challenging payer mix, we are not a hospital that has a benefit of having large margins in a normal year. The COVID period made things even more challenging for us because of all of the challenges that came with the pandemic. During COVID, we received a one-time payout that hospitals across the country received to help during that period. So that number is represented in the financial statements for those COVID years.
Okay. Next question. Are you saying that Johns Hopkins All Children's Hospital is forever operating in the, quote, financial red, end quote, and never makes enough money for upgrades to better your programs, surgical rooms, or even research?
Not forever, but for the past 5 years.
I think they know that that's baloney. I think that was almost like a sarcastic question.
3 of those 4, actually I'm looking at 4 years. 3 of those
I got
4
the bug.
years without the provider relief funds have been negative. And the one that wasn't, it was less than 1% margin. So very narrow margins.
Yeah, but 1% of a billion is a lot more than 1% of 100.
Means we have to tap into other sources.
A 501c3 is a nonprofit, but by no means does it mean that it cannot make money. I see just 1 year's tax balance sheet, and Johns Hopkins All Children's Hospital carry balance.
This is like a juror saying, I don't believe you. Just because it's a nonprofit doesn't mean it doesn't make money.
And assets, at least in the COVID bad income year 2020, about $1.2 billion. So am I correct that nonprofit does not mean no money?
Correct. Nonprofit doesn't mean that an organization isn't allowed to have funds available. Those funds are used to be able to expand and extend the mission of the organization. And it is the intent of those funds to be able to deliver upon the mission. That's the purpose of those funds.
You mentioned that every dollar goes to pay for items and it goes back into the hospital. Does
but Johns Hopkins All Children's Hospital does have, for just the 2020 tax file, in cash, securities, and assets, about 1.2 billion saved up in various forms that Johns Hopkins All Children's Hospital declared on federal taxes. So not everything goes back into the bill. Am I correct?
So the 1.2 billion that is on the balance sheet, that is not available. That includes buildings and lots of other assets that aren't accessible.
There must be a good, something's ringing. There must be a good Roach story from Recovery Addicts page, since everybody's talking about it right now. Belinda, thank you for gifting a membership, and McSpunky. The generosity continues. Tracy, you don't owe me anything. I'm here. I'm hanging out, enjoying time with you. I'll work some tonight after my kids go to bed. No big deal. I can catch up. Melissa, could the hospital consider settling out of court at this point? Longtime watcher, now a member. Woo. Awesome, Melissa. Yes, they could consider. My guess is they tried before the verdict, before the trial even started, but now there's a huge verdict. The settlement numbers are going to be bigger than anything they offered before, would be my guess, right? I don't know. I don't know what's happening in those conversations. April, random question, but have I ever been to the Masters? I think you meant, have I ever been? I have never been. It is on my bucket list. One day I will go. I'm scared to death of big roach bugs. Love the tree. Yes, Christmas tree over my, what is this, left shoulder.
It includes many different things. There are some, there is a portion of that is for strategic investments.
Mr. Shapiro, do you have any further questions of this witness?
Yeah. Just briefly, so the cash, if you have a shortfall, then you can tap into those reserves. Is that right?
That's correct.
Okay. And again, whether you have a profit of, 1 million or 33 million, or if it's a good year and it's a little higher, when you think of profit, all of that money goes back into saving children's lives in this community. Is that true?
Yes. It all goes to advanced mission.
Yeah.
Anything further?
Listen, and I don't mean to be like sarcastic about this, because I agree. They help a lot of people. They save a lot of kids' lives every year. A lot of hospitals do a lot of good work, but this is the same hospital who got all this money, millions of dollars, $1 billion company, and they abused a child. At least one child that we know of, right? So, I mean, I get it. That's kind of like.
Do the jurors have more questions?
Jacqueline, you're a champ. Thank you, Jacqueline. More questions from the jurors? Good night.
Mr. Shapiro, do you have any further questions? Mute your microphone. And Ms. Rogers, if you can unmute your microphone. Members of the jury, I'm not going to be able to ask that last question. Mr. Shapiro, do you have any further questions?
No, thank you.
Mr. Whitney, anything further? Okay, Ms. Rogers, thank you very much for being here.
Thank you.
Okay, members of the jury, what we're going to do is we're going to take a 10 to 15 minute break. I'm going to ask the court deputies to take your dinner order at this time. So it's going to take us a little bit longer for this break. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. We'll call you back in 10 to 15 minutes.
All right. Thanks.
Is anything we need to address before we take our 10-minute break?
The only thing I want to bring your attention on is it occurred to me, in this unusual situation, I need to move for a directed verdict on specific intent. Had it been pled and proved in the front end, I would have moved for it at the end of their case and at the end of all the evidence. But before this goes to the jury, I think I need to make the argument that they've never proved the evidence required for specific intent on any of these claims.
Okay, what I'll do is I'll take it under advisement. I'm going to allow it to go to the jury, but I will keep it under advisement. Okay.
Thank you.
Okay, 10-minute break.
All rise. Court in recess.
Azam, another dumb question. Is this phase to punish J Hatch? Right. What is the purpose of this? Is it so they can pay less punishment? Sorry, I'm confused. No, it's to pay more. So yes, it's a punishment phase, but specifically the way they're getting punished is by taking their money and awarding their money. So basically they say, this is bad conduct. It's so bad that we have to make sure you never do it again. Because if we just do the normal verdict, you might do it again. That might not be expensive enough for you based on how much money you have. So based on how much money you have, we got to make sure we punish you for it and deter you from ever doing it again. And even other companies like yours to deter them from doing it. That's what we're at right now in this phase. So money is a big deal. Objection. Yes, I am drinking a Celsius. Richard H., my question summoned the beast roach. That's on me. Peter, my bad. It is on you. It is on you. Settling means no appeals process. For the most part, yes. For the most part. Doesn't have to. The cool thing about settling is you can do a lot of things that kind of whatever you want in settlement, whatever both sides agree to. That's what you can do in the settlement process. I'm trying to figure out if I'm going to continue to stream this or leave and come back later and talk about closing arguments and the jury verdict if we ever get one. Tired. I'm hungry. I'm cranky, Peter. Angry, Peter. Clever. For Azam, your questions are brilliant. Thank you. Yes, I didn't even respond to that part because she always does that. She's like, maybe this is a dumb question. It's like, it's not a dumb question. I love it. I love it. This is potentially the longest stream I've ever done, and I am tired. I am tired. I will tell Whitney everyone loves the tree. Jillian, welcome. All right, here's what I'm going to do. I'm going to take off. My kids are home from school now. Hang out with them for a while. We'll see how the closing arguments go. If they come out with a verdict, I will go live again. I will either be back later tonight or tomorrow. We're definitely going to be live tomorrow morning at 10 a.m. with our members. If you want to join the membership crew, I haven't seen any news on Sarah Boone. Somebody just asked. The court will not be open tomorrow, June, I believe, which is why they're pushing it late tonight. April, it doesn't have to be a bucket list. I can make the Masters happen for you, and no, not a joke. Somebody mentioned this to me before, and they sent me something like they had tickets to potentially buy. I know there are tickets to buy. Let me know what you have, and I'll see if we can make it happen. Yeah, shoot me an email, lawyeryouknow@gmail.com. Brooklyn basement, potentially, but very unlikely to bankrupt the hospital. J Hatch is a subsidiary of Johns Hopkins, and they are a 501c3. Correct. All right, people, I love you. Thank you for riding this out with me. I'm sorry I have to leave now, but I appreciate you guys so much. And I hope that you'll come back and join me once the verdict comes down and we can talk about it some more and see what happens. I expect big numbers. And I expect yes on specific intent. So we will have to wait and see. That's all I've got. I am going to hit the outro now. Peace out. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, @LawyerYouKnow. But on Instagram, we are still @TragosLaw. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us lawyeryouKnow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.